society, country, even organization, even workplaces. So there are rules and regulations, the do's and the don'ts. They can also be tagged as law. So that's my layman understanding of it. Thank you.
All right. Thank you very much, Richard. That's amazing. That's interesting. I love the fact that everybody's just gearing up. The communication is flowing, and I'm sure you're going to love today's class. So, without further ado, let me introduce our attorney in the building, Mr. Ifeanyi Okonkwo. Mr. Ifeanyi, can you hear me?
Yes, I can hear you clearly.
Okay, amazing, amazing.
Yeah.
So,
Yeah.
can everyone kindly give a round of applause for Mr. Ifeanyi here, please? Attorney Ifeanyi here. Okay, Richard, I see you. You can also type in the comment in the chat box. I also see Lawal too is also clapping. That's amazing. So you can take over from here, Tony.
All right. Good morning, everyone. It's a pleasure to be here to speak to all of you, and I'm very glad your comments earlier on. It's very clear that we have students who know where they are going and know what they want. Yeah, like Lawal rightly said, uh, law is very important in every community, association, organization, country. What does it do? Law is a system of rules created and enforced by a governing authority to regulate behavior, maintain order, protect rights, and deliver justice within the society. And then there are four key purposes from this definition now. One is maintaining peace and order. Secondly, is protecting rights and freedom. Three, promoting justice. And four, regulating conduct. So, whether you're doing business, whatever it is that you're doing, if you have the law at the core of your mind, I'm sure you're going to go far because the government has done so well to regulate businesses and so many aspects. But for the purpose of this lecture for business, it has regulated our business so well. And then if most at times, those of us who don't follow through always end up either you find yourself on the bad side of regulatory authorities or you end up in a bad business plan. So it is important that we go through this lecture so that we understand the principles of law in the business sector and how you can relate it to the business sector. Yeah. So once again, my name is Ifeanyi Okonkwo. I'm a lawyer. I'm an associate at TOLG Advisors. Yeah, I basically handle private equity and venture capital. So business law per se. So let us move straight to the business of the day. So today I'm going to be sharing my screen now. We're going to be talking about the principles of law. Uh, Please confirm that you all can see my screen.
Yes, I can see your screen.
You can see my screen. Okay, perfect. All right. Um, Sorry, 1 minute. All right then. So today, objectives of today's learning, we're going to talk about the composition of the legal system in Nigeria. We're also going to talk about the rudiments of the Nigerian constitutional law concepts and separation of powers in the constitution. We're going to highlight the nature and sources of Nigerian law, how the Nigerian law came up about, and then we're going to know about the law of a person and of association. When we get there, I'll explain further. Then we're also going to talk about the law of administration of estates and trusts, law of property, rudiments of law of contracts, and law of tort in business. So, uh, so the composition of Nigerian law. So Nigerian law is based off of it has three main components. three main components. The first one is the English common law. So the English common law, there are common law countries where the British common law is practiced. Being that we were colonized by the British, so we inherited the British common law, and then it applies mostly in commercial, criminal, and civil matters. So based on that, it was adapted to our laws, the legislative sector. Now use those laws that was adopted to, make statutes, make legislations on different spheres of law. So and also now is also based on judicial precedence. So judicial precedence is case law. So what it means is uh, when a court gives a judgment on a particular case, that judgment becomes law. That judgment becomes law. So now, if two disputing parties are faced with a similar dispute and they go to a court, so one of the lawyers will have to direct the mind of the court to that previous decision, and by that, the court is bound to give its judgment based on that decision from the
Oh,
higher court. So that's what you call judicial precedent. And we also have the customary law. The customary law is based on the traditions and customs of different ethnic groups. So, based on those traditions, laws also come up from that. And then it applies in family law, example, marriage, inheritance law, land ownership, local community disputes. So this is where you apply those customary laws. But anything outside of this would have to go. The law has to be applied. What has to be applied is the usual legislative laws that we have. So customary laws are being enforced only in customary courts. You will find them in your community. If you go to your village, your town, you will always find a small customary court which is headed by presidents of those courts. These are lawyers, yeah, but they're not necessarily judges or magistrates. They're just presidents of the court. They're lawyers who are just appointed to head those customary courts. And one major component of a customary law, for a customary law to be valid, it must not conflict with public policy, natural justice, equity, and good conscience. If the law does not pass this test, it cannot be law. It can be thrown out upon appeal. And then we have the Islamic Sharia law. The Islamic Sharia law it applies only in the northern states of Nigeria, only in the northern states with majority of Muslim population. So it's based on the Quran, the Hadith, and the Islamic jurisprudence, which is the fiqh. So, and these their laws applies just like we have our own customary laws for the South. The North uses Islamic Sharia law. But when it comes to matters of states and federal, the federal and state laws will apply. But customary issues that borders on culture, they use the Islamic Sharia law, which is now enforced in the Sharia courts. So we're going to briefly talk about the court structure in Nigeria. So we have a hierarchy of Nigerian courts. We have the federal courts, we have the state courts, and then we have the customary courts. So for the federal court, these are where the federal laws are being applied. One is the Supreme Court, which is the highest court in Nigeria. Then we have the Court of Appeal, we have the Federal High Court, we have the National Industrial Court, which deals only on labor and employment issues. So if you're having a problem with your employer or your employer is having an issue with you, that is the only court you can go to file your claim. You can't go to the Federal High Court, you can't go to the State High Court, you can't go to a Court of Appeal, nothing. You go straight to the National Industrial Court because that is the only issues that court is being set up for. Then we have the Code of Conduct Tribunal for public officers. So most public offices have Code of Conduct Tribunal, like the police, the army, some other public organizations. They have a Code of Conduct Tribunal where the ethics of public officers are being adjudicated upon. Then when you come to the state courts, at the state level, we have the High Court of the state. We have the High Court of the state. And then after that, we have the Magistrate Court. And then we have the Customary Courts. And then also the Sharia Courts, which applies only in the northern states. So we're going to now move on to but before we move on to the rudiments of the constitutional law, I also want to highlight a little bit on the hierarchy of courts. So, uh, when you have when you have a matter, let's say you have a case. I'll start from the lowest to the top. So, when you have a case in the Sharia court or the customary court, at the end of the day, you're not satisfied. You can appeal to the magistrate court of your state. Peradventure, you go to the magistrate court, you're still not satisfied, you can appeal to the high court of your state. So if you still go to the high court of your state and you're still not satisfied with the judgment, who can tell me where you send your appeal to? Can someone briefly tell me where you can send your appeal to?
The Federal High Court, sir.
No. Thank you very much for your answer, but that is not correct. The Federal High Court and the State High Court are of concurrent jurisdictions. They have the same, just that the Federal High Court deals with matters of, it deals with federal issues which is outlined in the Constitution. There are some federal issues that's what the High Court handles, which is matters on, let's say, company-related issues, drug-related issues, and matters of customs and excise duties, aviation, stuff like that. Those are the issues the Federal High Court deals with. But the State High Court deals with certain issues of the same level as well. But you cannot appeal from the point is you cannot appeal from the State High Court to the Federal High Court because they are of concurrent jurisdiction. Just that the Federal High Court deals with federal related matters. So if you have a federal related issue or two companies are into, or maybe you want to apply, a company is owing you, they don't want to pay you, you can apply for winding up of they can't pay their debt, you can apply for winding up of the company. You go to the Federal High Court. Do you understand? So now any appeal from the State High Court goes straight to the Court of Appeal. You can't go to the Federal High Court. It goes straight to the Court of Appeal. Then, after the Court of Appeal, a further appeal will now go to the Supreme Court of Nigeria, which is the highest court in Nigeria. If after the judgment of the Supreme Court you're still not satisfied, then you can go to God. God is the next in line. That's the end of the line. So, without further ado, we move straight to the rudiments of the constitutional law, where we're going to talk about the concept of separation of powers in the Constitution. So, it goes without saying that the Constitution is the supreme law of the land. Okay, it sets out framework it defines the structure of the states, guarantees your rights, and every public authority, private, even individuals, must act within the limits imposed by that Constitution. So it also goes to say that any law that is legislated upon, any law that is given force that goes against the provisions of the Constitution, that law becomes void. As long as if it goes against that law, the Constitution will always, you know, take a head step before that law. Now, federal structure. We all know you did your government in secondary school, so I'm sure you know about the federal structure. I'm just trying to rush so that we'll meet up with time. Yeah, so Nigeria is the federal republic, which is made up of 36 states, and then today, as we all know, there's there's a call for creation of new more states, pending when that comes. For now, we have 36 states. And then the idea of this structure is to accommodate the diverse ethnic and cultural, you know, and ethnic and cultural differences, and then also promoting national unity. Uh, Fundamental rights and rule of law. So the Constitution enshrines various rights. Chapter 4 of the Constitution mentions all the rights that you have as a Nigerian citizen. It mentions where you have right to life, you have right to dignity of your person, you have right to personal liberty, you have right to fair hearing, right to private and family life, you have right to freedom of movement, right to freedom of thought, conscience, religion, you have right to freedom from discrimination, you have right to acquire and move immovable property, you know, there's also some restriction on derogation from fundamental human rights. So chapter 4, just go find a copy of the Constitution, go to chapter 4. Chapter 4 talks basically about the fundamental rights that you have as a citizen. So, and these rights are protected by the judiciary, ensuring that state actions and also personal individuals do not infringe on people's rights and freedoms. And then we now move to the separation of powers in Nigeria. We have three arms of government in Nigeria, which is properly provided for in the constitution. We have the legislature, we have the executive, and then we have the judiciary. What does the legislature do? The legislature, it is their job to make laws. Section 4 of the constitution gives them that power. Their job is to make laws. So the legislature comprises of the National Assembly, there's the Senate, and the House of Representatives. These three houses, their job is to make laws in the country. So the National Assembly makes law at the national level, and then the Senate and the House of Representatives, they make law on the federal level. Then the executive is, which is the presidency, their job is to implement and enforce laws. So that comprises of the president and his cabinet with ministries. Their job is to enforce these laws. Then, what is the job of the judiciary? Judiciary is empowered by Section 6 of the Constitution. They are entrusted with interpreting laws, ensuring justice, just acting as guardians of the Constitution. That's what the judiciary does. So, and then these three arms of government also checkmate each other. But it's unfortunate what we're seeing today uh, in today's politics, where there's a there's a blatant rape of this separation of powers, where the the executive arm just overrides everyone. But that's a story for another day. But the constitution provides for checks and balances regarding the separation of powers. Legislature can check the executive orders through. So let's say the executive arm is just taking more than they can chew. The legislature is empowered with impeachment. They can start up impeachment processes, and with that they can override the president's veto power. The executive can influence legislation by proposing legislation. So the president can come and propose the legislation, or we want you to do this, do that, and then we can exercise their veto power. And that is this veto power today is what is being abused. Is what is being abused. This is one of the points in the constitution that is being clamored for review, because the veto power has no checks. The president can come and just, you know, exercise his veto power, impose a law, and we can't do anything about it. So now the judiciary, it is now our duty to review these laws that are being created by the legislature, you know, and ensure that they conform with the constitution. So this is what we call judicial review. So for each law that is being done is sent to judiciary. Judiciary will have to review this law and give its comments before it's passed as law. So like I have said, that the separation of powers is not watertight. There are loops here and there, but you know, in the nearest future, we're hoping that this tyranny and abuse that we're seeing today is going to come to an end by God's grace. So we'll move straight on to the nature and sources of the Nigerian law. Nature and sources of the Nigerian law. So I said it earlier that having sprung up from British colonial system, we had to inherit some of the English common law. So the Nigerian law it reflects the country's legal pluralism because with so many diverse cultures, we had to mix a whole lot of things to make up our law that we have today. And our law is characterized by the English common law, customary law, Islamic Sharia law, which is applicable in northern states, and then the statutory written laws which we have. Those are the acts, the statutes, and then hierarchical structure. So our law is applied in a tier court system with the Supreme Court as the leader, followed by the Court of Appeal, High Court, and then other subordinate courts. You see, he didn't say Federal High Court and High Court. He said High Courts, which shows you that the High Courts have concurrent jurisdiction. And our laws are subject and accountable to the 1999 constitutions. The law is sovereign. There's dual sovereignty. So as a federation, our laws are made at both federal and state levels. Both federal and state levels. Federal to cover the federal, federal issues. State level to deal with just state. So it is a way also to really reduce burden from the courts. You don't have one court dealing with every single thing. So there are specific courts that you and we find that today in practice. Even some lawyers make that mistake. Every day you go to a court, a lawyer will file a case, the other lawyer will file a preliminary objection saying that this case is not supposed to be in this court. This is not it's not supposed to be in this court. We should go to the state high court or we should go to the federal high court. Yeah. So now let us talk fully about the sources. So the constitution, it is the supreme law of the land, and it derives its validity from our laws. Or every single law that we have derives its validity from the Supreme Court, from the supreme law of the land, which is the Constitution. And we have the legislation, which is made by the National Assembly on federal level and State House of Assembly at state level. Examples of these laws the Criminal Code, the Electoral Act, Petroleum Act. These are the kind of laws that you will find that are made by the National Assembly and the State House of Assembly. Then we have the case law, judicial precedents, which I had explained earlier. Case laws, like I said, when a court gives a judgment, most especially a higher court, other lower courts are bound by that decision. So when they are faced with similar cases, they must follow the decision of the higher court. It's called judicial precedent. It keeps order. So, but also in a case where a higher court gives a wrong judgment, that's where judicial review also comes into play. So the lawyer can apply for that decision to be reviewed. Or, my lord, we cannot follow the decision of the higher court because it is flawed by this and this. I have filed an appeal to the court for the court to review its decision. So this also puts a check so that we don't follow obsolete laws. And then we have the customary law. The customary law, like we said earlier, is genius.
Lawyer, sir. Lawyer, sir, before you go ahead, sir. Good morning, sir.
Yes. Sorry, who's speaking?
Good morning, sir. All right,
Who's speaking?
I'm Dr. Dejide. All right, good morning, sir.
Okay, go ahead, sir.
I just wanted to quickly ask a question because I mean this judicial precedent is always very confusing for me. So
Mm-hmm.
let's assume the higher court has made a decision. They've let a certain criminal or they've permitted something that they should not have permitted.
Uh-huh.
Now somebody now wants to leverage that particular decision, and the
Mm-hmm.
other lawyer is saying no, this does not work.
are they ever going to reverse what was done already? And because I mean, they've already let somebody go, they've already passed a certain judgment in the past. Are they going
Mhm.
to undo that? And when they don't, when they can't or they don't do that,
Mhm.
what will then happen in this new case where the guy is saying that we cannot use that old judgment as the basis for this new one? What will be the basis? What will be the process whereby that whole old judgment is now discarded?
That yeah, thank you for your question, Orlando. Very good one. Like I had said earlier, the issue of appeal. So when the court gives, it behoves on the lawyer to point out the anomalies in that law. But when a judicial precedent, the way our laws is, when a judicial precedent has been pointed out in court, in your filings, in your pleadings, the court is bound to follow that decision. Now you go on appeal. So let's say that judgment was given by the state high court of Lagos State. So there, and that judgment was, it was that judgment that was the judicial precedent came from the court of appeal. So you can now appeal to the court of appeal, or I mean, when this judgment or the judge erred in law by giving this judgment based on this, based on that, we're applying for the court to review its judgment on this issue. So now the court of appeal is going to look at your briefs of argument and now review its own judgment. You get my point? The Court of Appeal will review its judgment in this case. And now based on that, but it doesn't when you now talk about going back to, let's say somebody was in prison already. Now that is now left for the person's legal team to now say, oh yeah, my client was convicted based on this law, which has now been reversed. We're applying for a judicial review or we're applying for the judgment on this case to be set aside. Based on that, the judgment will be set aside and the person is free from prison.
Okay, okay, interesting. All right, thank you very
Yeah.
much. Thank you,
Okay.
thanks. All right.
Okay. Yeah. Please, sorry, we're trying to follow time. If anyone else has a question, please kindly put it down when we get to the Q&A session. Then everyone you can shoot me what you have. Yes. Thank you. So um, we're going to go back to where we were. So customary law. So customary law I mentioned earlier is indigenous to the ethnic and community customs of that particular community. But it is only recognized, it only has the force of law if it goes through it is called the repugnancy test. Repugnancy test. What is the repugnancy test? That law is not repugnant to natural justice, equity, and good conscience, and are not incompatible with the written law, with any written law. So now, for example, there's a case at the Supreme Court, that's OKK versus OKK. So that in that particular case, it is this issue of inheritance rights for women. So this lady, her father died. You know, the man was a rich man, and you know how it is in most Igbo communities, where they say that the woman is not entitled to inherit her father's properties. This lady went to court because the brothers took all the properties, they didn't leave her. Yeah, yeah, they had their argument was, oh, you're married, you're no longer part of the family. But the law is very clear that a child is entitled to inherit the father's property. There's no, and then you now saying because she's the female child, it goes against the constitution, which gives rights, freedom from discrimination. So, based on that law, the Supreme Court, in its wisdom, has now put that customary law aside. Every female child, no matter the ethnic group, you are entitled to inherit from your father's property. So, that law didn't pass the repugnancy test, and it was set aside. So, goes to show all other customary laws. There's some bizarre practices in some community where a husband will die and the woman is made to drink water that was used to bathe the corpse and all that. I mean, so and they will tell you, oh, it's custom, it's our law. They go to a customary law and they're arguing it, but that law does not pass the repugnancy test. So with math and also other similar issues. So this customary law, it governs issues on marriage, land, inheritance in traditional settings. And then also we're now also going to look at Islamic law. Islamic law applies only in northern states, in some northern states. And it covers issue of marriage and inheritance and land, and in some states, criminal, especially in Kano, Kaduna. Their criminal adjudication is based on the Sharia law. So when they have a criminal case, when they go to their state high court, they don't use the criminal code that we use. They use the penal code. The penal code is the Sharia criminal law. And then we have the received English law, which is the laws that we inherited from England, which is the common law, doctrines of equity, statutes of general application in force as of January 1, 1900. So most of those laws were adapted into our laws, and that is why if you visit England, if you go to their courts or you check their laws are online. It's very similar to what we have, or if not a carbon copy. Uh, So these were introduced during the colonial rule and still applicable, except some have been repealed. So many have been repealed and they were written by new laws now, which were made to, align with current state practices. And then we have the international law. International law are laws that come up from treaties and conventions, of which Nigeria is part of those treaties. For example, the ECOWAS and UN treaties. But before those treaties become law in Nigeria, Section 12 of the Constitution says that that treaty must be ratified by an act of the National Assembly to have force of law. So there are so many cases where so many treaties that Nigeria has been part of, but because of some political reasons, some of those treaties hasn't been domesticated as laws for political reasons. They're just playing pranks over there. But just like you have uh, uh, there's so many discrimination, most also the constitution that we have today, those rights that came in chapter 4, most of them were from treaties of international treaties that Nigeria was part of. So you have to domesticate it. And when you don't make this law, the UN can sanction countries for that. And that is why and that is why in South Korea has been sanctioned by so many countries, by even the UN, but they don't care. They basically they don't have rights over there. South Korea is not a place you want to be, trust me. And we'll move on so later on you can just look at the summary table of all that we've discussed. So now we're going to move to the law of person and association. This is a very important aspect. So this area of law recognizes, the rights and duties of persons. So one, natural persons. We have what we call natural persons and juristic persons. I will explain later. So, but natural persons refers to human beings, and every individual is recognized as a legal person from birth up until you die, and you are entitled to own property, to sue and be sued, to enter into contracts, or be held liable under criminal or civil law. But then there's a limit to legal capacity, depending on the jurisdiction and your age and your mental intellect. So not all persons have full legal capacity at all times. So in Nigeria, minors are seen as people under the age of 18. So for under the age of 18, you have limited capacity. So as a minor cannot enter into a contract without uh, a guardian in place in that contract. So that's why you see somebody who wants to buy land for their children. The deed of assignment is going to read the child's name, and then the guardian will now be there. legal guardian, and the person's name will be there because the person is a minor. So the person does not have full capacity to enter into a legal contract. Then persons of unsound mind may not be liable or may not validly enter into any contract. Then foreigners. Foreigners are legal persons, yes, with their rights, but they will face limitations because as a foreigner, before you're able to enter into some contract, there's some requirements, there's some things before you can come into Nigeria and do business, or before you can even go to another country and do business. There are some laws, there are some regulations that you must have to meet up with, like in Nigeria, the NOTAP and all that. You have to always register. And also, for a foreigner to do business, to register a company in Nigeria, you must come in through, there's some, either you come in as the FDI or FPI and register as a foreigner before you're able to. So those are the limitations. And then legal rights, like I said, Chapter 4 of the Constitution, all your legal rights and duties are all enshrined in Chapter 4 of the Constitution. Right to life, right to privacy, expression, freedom of movement, etc. So you can read that up later. Then juristic persons. Juristic persons are artificial persons. These are not natural persons per se, but these juristic persons have legal personality and are recognized by the law. What example of a juristic person? A company. So a company under the Company and Allied Matters Act of 2020 is uh, recognized as a legal person. So you and your friends come and you register a company. You and your friends are separate from the company. You, a director or a shareholder, you are a separate legal person. The company is a separate legal person. Let me explain in context. So now, you you and your friends run a company and you run into maybe a debt or something. You are only liable as a member of that company to the number of shares that you have. So let us say the company is owing 100 million, and you have 20% shares in the company. Your liability is only limited to the number of shares that you have in that company. So when you contribute your own 20%, you go and rest. So if at the end of the day, you're at the company is still not able to pay up the money, then they can now go for the debtor, they can now go for something you call winding up, and they wind up the company. But you are not, whatever debt or liability has nothing to do with your personal assets. So they cannot say, oh, you all have come up with this amount of money, it's still not enough, and then they start going after your personal assets. No, you only go after assets of the company because it's a person on its own. So uh, that's the case of Solomon versus Solomon. It's a very popular case. And then business names, but then business name, it's not an artificial. It's a juristic person, but it's not per se because you are not separate from the business. So, because when you register, well, you can register businesses in different, like in different modes. You can either register as a limited liability company or a public company, or a business name, or a partnership, or an incorporated trustee. But for business names per se, business names specifically, the legal you're not it's not different from you. So I would call it you're one and the same person with your business, unlike you have it. Unlike you have when you register as a limited liability company or a public limited company, whichever. Then the same thing with partnerships. You're not distinct legal persons. You're all the same thing with business name. But incorporated trustees, these are churches, NGOs, associations. The trustees are separate. They're separate legal people from the incorporation, from the church, from the association itself, or from the church itself. So uh, 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 Pastor Adebayo now is different from his church. His church is a separate legal body. He is a separate person, as much as he is a trustee. This NGO now, Transformation College is a separate legal entity. The trustees are also separate legal persons from from the association. So, and then we have trade unions, cooperative societies, and clubs. This also comes under incorporated trustees. What are the legal consequences upon incorporation? So, upon incorporation, one, you become a legal entity. Members enjoy limited liability. That limited liability, which I explained in your liability is limited to the number of shares that you have. That is the meaning of that word, limited liability. Then the entity continues to exist despite change in membership. So a company can start today with three directors. Tomorrow there can be a rotation of directors. They are new directors, new shareholders, but the company still remains. So despite the change in membership, that legal personality of that company remains. The company can own assets, enter contract in its name, and that's why you will see some contracts also. Like Dangote refineries. Dangote refineries is a person on its own. It's different from Aliko Dangote. What are the key differences? Yeah. So for natural persons, uh, uh, you're recognized upon birth, but for juristic persons, you're recognized by law, by your registration, or by statute creating that association. So if that's why you see some people another mistake that people do in business. I'm going to point it out now because of this recognition. A lot of people come up, oh, I want to do business with this name. They just answer one big name. I'm MD CEO of Chukwemeka and Sons Limited, but they're not registered. He's going about doing business with Chukwemeka and Sons Limited. He go enter into a contract with Chukwemeka and Sons Limited. And then at the end of the day, Chukwemeka and Sons Limited does not exist. So that is one thing. By the time you advance in what you're doing, you also find that before there's something we call legal due diligence. When you're entering into a contract with somebody, be sure that you get requisite legal representation. Be sure that your lawyer confirms that the company that you're going into business with is actually registered. Because if at the end of the day it's not registered, you are on your own. How do you go about it? So you went into business with somebody with a company that does not exist. So who are you suing? Those people can disappear. You don't have anybody. But if the company is registered, yes, you can fish out the directors. And also another thing is people go out doing branding. Do your branding, but your entity is not registered. Your entity is not registered. Then tomorrow somebody else starts business with the same name and the person is registered. But you've already gotten a good customer base with that name, with that brand name, and you're not registered. At the end of the day, you find yourself trying to rebranding because for just because you don't want to follow due process or share ignorance. So recognition by law is very important for juristic persons. Very, very important. As a natural person upon birth, you're already recognized by law, but for an association or a company, recognition only you only get that recognition status upon registration. Then legal identity. For natural persons is individually, for juristic persons you're separate from the members. Juristic person is different from the members of the company. Lifespan for natural person is upon death. So whatever contract you have with somebody, that's why as soon as the person dies, by law, that contract dies, except you put a clause in the agreement that also brings in their personal assigns, their heirs, and legal representatives. But for juristic persons, it's perpetual as long as the company is still in existence. As long as registration status is still active, it is perpetual. Uh, Liability for natural persons is personal. For juristic persons, it's a limited liability. Yes, both natural persons and juristic persons can sue and be sued. So that is all about natural and artificial persons. So now we are going to move on to the law of administration of estates and trusts. Law of administration of estates and trusts. So this basically has to do with uh, legal process of distributing or managing someone's estate upon their debts, their assets and liabilities upon their keynote on assets and liabilities, because you find some people, uh, their father dies and they are all just rushing, oh, let us try and gather all our father has. Mind you, also, yes, you're taking its assets, but also liabilities are inclusive. Liabilities also are inclusive. So if the business deal, the contract that brings in personal representatives, legal representatives, heirs, mind you also that you have to also take up those liabilities. So when somebody dies, when somebody dies, is a claim that the person dies either in under the administration of estate. The person dies in both ways. It is either the person dies testate or the person dies intestate. So when the person dies testate, what it means is that the person made a valid will upon his death. Then when a person dies intestate, what it means is that the person died without a will. So when the person dies without a will, what do we do? That's where you now go to court as the beneficiary, and then you file for what we call letters of administration. So based on that letters of administration, you can take that to the bank or wherever it is, or just you can use that to claim access of the deceased person. So the court will have to look at those making the application, making sure that you're valid beneficiaries.
Sorry to
And then,
cut you, sir. You kindly check the chat box. Some comments have been made. To...
okay, okay. Uh, okay. Sorry, hold on. Okay. Yes. Who said this? Edith. Okay, Edith. Yeah, this is what I just explained now. Um, yes, when a party dies, whatever contract the person had with dies with the person, and then, but then, if you check the nature of contracts that are being drafted today, you would see, let us say, Ifeanyi Okonkwo, Party A, Ifeanyi Okonkwo of so and so place, Lagos State. In brackets, you will see inclusive of, which also connotes uh, personal representatives, legal representatives, heirs, and successors in title. So that contract automatically brings in you and your beneficiaries. I don't know if I can hold on. I'm going to try share for context to answer this question. I'm going to share a contract, copy of a contract with you now. Uh, just give me a minute. Give me a minute. Okay. Uh, so I'm going to do interesting codes. So I'm going to bring out two contracts. One is a contract between individuals, and then I'm also going to show you a contract between companies. Okay. Let me start with the one for the one between companies, or a company and a person. Okay, let me just do one between a company and a person. So this is a recording agreement. I don't know. Can you see this screen right now? Can you see my screen? Can you see the exclusive recording agreement that I'm putting up? Hello? Can you hear me?
Yeah, yes, we can hear you and we
Yes,
can see you.
yes, you can see.
You can see this exclusive recording agreement. Okay, fine. So
Yes.
now, this is a record label deal that that my company had done. So now, you will see High Frequency Vibrations Limited is a company. Okay, So a company duly incorporated under the laws of the Federal Republic of Nigeria and having its principal place of business at, okay, which expression shall, where the context so admit, include each successor's in title, legal and all personal representatives. So this brings in every member, as long as that company exists, every officer, every principal officer of that company. And then the second person is going to be an artist, so it's going to be a person. So here you see which expression shall, where the context so admit, include his or her heirs, assigns legal and personal representatives. So this automatically brings in this person's uh, beneficiaries, assuming this person is no more. So if there's any financial or unfinished business, especially financially, his representatives, his beneficiaries will have to take up that responsibility. Edith, am I clear now? Edith, am I clear?
I think
Okay,
she's off the call, but it is
okay,
clear.
okay. All right. We're going to continue. Uh, so a valid will tested succession, and then the law of intestate succession is going to apply if there is no will. So personal representative. So A, who is a personal is the person authorized to administer the estate. So this person could be an executor where there's a will. If the deceased person had a will, the person is called an executor. So if the person does not have a will and dies, so it will be the person appointed by the court, which is the administrator. That's why you call it letters of administration. So, what grant is being given? So, is you're granted that right to legally administer the estate of the deceased person. So, that representative must obtain a grant of probate. So, when there's a will, you just take that will to the court, and then the court is going to give you, it's called a grant of probate. So, with that grant of probate, you can go ahead and administer the estate of the deceased person. And then for letters of administration, you'll be given that. With that, you can take that to the bank or to any company or to any stock, to if there's any shares that the person has, and you take all of that. With that, also, you can use that letter of administration to also manage the person's properties. So if the person had properties, you can continue management with that letters of administration. So these are issued by the probate registrar of the High Court of a state high court, not federal high court, because this is a state issue. So with this, you go to the state high court where the deceased person lived. So if the person lived in Lagos State, you're going to go to Lagos State High Court. If the person lived in Anambra, you go to Anambra State High Court. If the person lived in Abeokuta, you go to the Ogun State High Court. So testic succession, so it occurs when a person dies, leaving a will, said that, and but then it must comply for that to be valid. It must comply with, we call it testamentary capacity, voluntary act, and proper witness. And what does this mean? So the person who is making the will must be of sound mind. There are some people that act very, very funny. Their father would is on the verge of dying, and then they just go prepare a will, put the man's fingerprints there, or just force him to sign when he's not even mentally uh, in order to make such testaments, so that they can have easy access to the properties. So, but the court said the person must have good testamentary capacity. How do you do that? The best way to do it is you get a lawyer must be present or an officer of the court, and then there must be at least two witnesses, and he must give that testament in the will in the presence of the two witnesses. So, witness A cannot come and sign in the absence of witness B. So, witness A and B must sign in the presence of the deceased, of the deceased now, and he must write his will in their presence. Two of them, everybody, the three of them must be present there. That's what you call proper witnessing. So if these legal requirements are not met, that will be declared invalid. So I have already explained the intestate succession when the person dies without a will. So trust. What is trust? So trust is a legal relationship where one person holds property in benefit of another. So the way we do it is, let's say I want to give you, I want to give my son a property, but people do it for some other legal technical reasons, where you because there's some fees you have to pay if it's an outright deed of gift, and all that. But when it's trust, so you're saying, oh, so that's why you have some companies who deal on trust. There are some trust companies. So all they do is, okay, fine, you hold this property on behalf of my son, on behalf of my child, on behalf of my daughter, pen at till they attain to so and so age. So the settlor, which is the company, would create that trust. The settlor is the person giving the property. He will create the trust. So the trustee company is the company that manages that trust property. Then the beneficiary is the person who receives the benefits. The trust property is that asset which is held in trust. And then what instrument do you now use? The legal document you use to do it is called the trust deed. The trust deed. So it is held by the trustee company till the time frame, whichever when they are now going to dispose of the trust property on behalf to the beneficiary. So with that, people use that to run away from estate fees. So instead of when I die, my children will have to go to court, pay estate fees, pay administration fees before. I think the government takes about 10%. So let's say the man left 100 million naira in his account. The court will have to take 10 million naira, 10%. Yeah, but you can bypass this by creating trust. Pay the trustee company a meager amount depending on what you negotiate with them. So it's just another form of bypassing the trust. So trust, it is intentionally created either in wills. Some people mix it up with the wills, but I think it doesn't really make sense. The best is just do a trust deed. Then it's imposed by law. So the property returns to the settlor or their estate if the purpose of that trust fails. Let us say, unfortunately, maybe the child dies before the dad or something. The trust automatically returns to the settlor. So the duties of trustees, they must act in good faith, keep accurate accounts, avoid conflict of interest, always act in the beneficiary interest, in the beneficiary's best interest, because at that point you have no business with the settlor anymore. The settlor has made the trust deed. You have the trust property. Whatever you're doing is in the best interest of the beneficiary. So the settlor cannot just come and want to alter. There's there's so many legal requirements that the settlor will have to, you know, meet up with before they can alter that trust deed. So these are the applicable laws, trustee laws of various states, and then other also common law and equity principles. So you can read up on that later. Uh, Summary. Okay, you can go ahead and read that up later. I think we still have time. It appears I rushed this. So, please, moderator, please. So I don't boggle people's minds, so that we can let us take one thing after the other. So I think I want to stop here. Then during the second session, then we can now take the Q&A. I want to rush the second session and take it. So what I want to do now is let us have a brief Q&A for what I have said so far. So we don't rush so many, because I know some people have low attention span. I have that problem as well. Uh, so I don't boggle our minds with so much. So if there are questions you want to ask, based on what we have said so far. Let us do that now, and then during the next session, we can do the next session and also do a brief Q&A. What do you think, moderator? Damola, what do you think? Is Damola here with us?
Lawyer, thank you very much, sir.
Yeah, thank you.
Thank you very much for all that you have said. You know, this law, this area of law is a very even for. I like the way you said that even the lawyers make mistakes. They go and file something in the wrong court. Why is it like that? Why is it that you can? It's like in Nigeria, right? You can go to one doctor, and the doctor will give you a completely different diagnosis from what another hospital will give to you. Also, when it comes to some of these things, when it comes to the law, they're completely documented. The constitution is clear, the law is clear. But how come there are always differences in the interpretation of the law? I mean, permit me to use this River State issue. Where people,
Mm.
where people could prove categorically that this is a violation of the law, but the what's the name of the person? The council general for the federation said that they haven't broken any law. Why is the law subject to all sorts of interpretations, though it is adequately documented?
Yeah. Yeah, okay, that's a very good one. That's a very good one, Orlando. So the thing is, law is very technical, and please let's call it spade a spade. Hmm? Let's call it spade a spade. I'm a realist. I don't like to beat around the bush or try to. The draftsmen for our laws. When you read our laws, if you read our laws hand in hand with, let's say, an act, a U.S. law, the U.S. laws are always very, very clear and straight to the point. But then most of our laws is open to so many interpretations. Some of them are vague, which is not, which shouldn't be the characteristics of a good, well drafted law. So and then most of these things are also politically motivated. So who are the people that draft these laws? Members of the Senate and members of the National Assembly and the House of Reps. While drafting this law, some of them purposely put in, well, allegedly, don't put me anywhere. Most of them, they purposely put in loopholes that, can be subject to a whole different, a wide spectrum of interpretation. So it makes it difficult. Then also, practice. In practice, most of the laws, in fact, while we're in law school, most of the things that we were taught, when you come in practice, you see that it's a whole different ball game. Yes, it's documented, but in practice, uh, there's a slightly different way around it. Now you have to, and also experience comes to play a part. Experience plays a part. So, and that's why we don't have it 100% set in stone because of these anomalies. It's a big issue, and that is why if you have an experienced attorney for whatever it is that you do, it will serve you more. You are going to, of course, so because when the attorney is now going to put in experience in what they are doing, to be sure that they get the best possible, results for you. Yeah, but the problem is from our draftsmen. Our draftsmen, they can, so you now come to court and see everybody's writing on technicalities, which shouldn't be. Instead of agitating upon the matter, we take two, three, four, five adjournments, deliberating on technicalities before we go to the main subject matter, which shouldn't be so. So that's the problem.
Thank you very much. Thank you for that. I don't know if there are any other questions in the chat room.
Someone said, how do you clearly differentiate the question of will and trust? Okay, I'm going to say it again. A will is different from a trust. A will is how do for wills, will is saying is a testamentary document. It's a document. One page. Oh, fine. Upon my death, first of all, I'm appointing this person and this person to be the executors of my estate, and I want this to go to this person. I want this to go to this person. So it's very, very clear. And then after that, it's filed in court. But then both of them are similar in a way. But what a trust deed is, trust deed, you cut for a trust deed, you cut away the court system, you cut away the probate registry. So what you have done is you do a trust an agreement between you and a trustee company with the beneficiary as the nominal party. Upon them attaining a certain age, I want to give this to this person. Upon them attaining a certain age, you handle this, make sure that everything is in place. Give this to my child upon them attaining the age of 25. Help them set them up as directors for this company upon their attainment of age of 25. Give them this property, so it's very so after that the trustee just keeps like at the end of once it gets to that point, the trustee begins to act. They just file all necessary documentation. So most times one major difference is that for trust deed, it mustn't be upon death, but will has to be upon the death of the testator of that will. You start acting upon the death of the testator of the will. But for trust deed, it doesn't necessarily have to be upon the death of the person making the trust deed. Is it clear?
Uh,
Absolutely, sir. Thank you very much.
Okay. Also, someone said, Rashid said, does the Supreme Court make an error? If yes, how would they correct it? Yes, of course. The Supreme Court has so many times made errors in their judgments, and what they do, you just apply for them to review. Now you apply to the to that to the to what they call them, to the Chief Justice of Nigeria. You apply to the Chief Justice for a review of the decision of the Supreme Court, and then they just have to look at it. If it has merits, they'll get back to you. If it doesn't have merits, they'll tell you that the decision stands. So the Supreme Court is their decision is that's the end most of the time. But there are just few cases where the court has had to revisit its decision. Very few cases.
all right. Before we round up the the question side of things, two things.
Welcome, sir.
Number one, everybody is always talking about, I mean, the efficiency of the court system in itself. So look at what you just said right now. Are there timelines that we're certain that they will get back to us? Does it typically take them a month, 2 months, 3 months? Some people even leverage the inefficiency of the court system to delay.
Sorry, I didn't get your question. Can you start fresh? I didn't get
I
you.
was talking about the efficiency of the court system. Can you hear me
Okay.
now?
Okay,
Eh?
yeah, I can hear
I'm
you.
talking
Yes.
about the efficiency or the inefficiency of the court
Mm-hmm.
system. So
Yeah.
you talked about, taking maybe you have a different opinion from some with regards to something that has already been taken to a judgment that the Supreme Court has made. You can write to them. Typically, are there SLAs, timelines by which you can expect that they will get back to you? Does it take a year? Does it take 2 years? Because I know a lot of lawyers that take advantage of the inefficiency that they know that in the system with regards to their cases. So that's number one. Also, on the
Yeah.
other thing around trust. So, for example, if somebody calls me to come to do a certain business and I don't necessarily want to put my name in there, can I get how do I now structure a trust? Do I get a lawyer to then say, well, this lawyer will stand in on my behalf, or how do things like that? How do they work?
Okay. Okay. Um, For the first one, well, you can't really say, because one, I know that appeal courts are saddled with a lot of cases. Appeal courts are saddled with a lot of cases. So most times you may not get a response timeously. Okay, but yes, finally, that's true. Some lawyers leverage on those inefficiencies, but the least you can do is apply and just have, and then be sure that you have somebody following up on this, on those requests, on the appeal. So it's but when you appeal, the appeal the last appeal that we did to the Court of Appeal, we filed the appeal, and we were given a court date in about 40 days. In about 40 days, we had a court date. So you can't really say it's a matter of it's an administrative issue, which I can't really give a particular timeline. But as soon as you file timeously, and your documents are all correct with necessary requirements in place, yeah, I'm sure you will definitely get a response. But I can't say about the timeline. Then the second question that you asked, that is where I don't know if you've heard about what you call a power of attorney. So when you want to carry on a particular task, but you don't want to, be there or be in the, so you can do what we call a power of attorney. Power of attorney is where you either you give either your legal representative, either your lawyer or your manager or somebody. It doesn't have to be a lawyer. So you give them a power of attorney, act direct, giving them the authority to act for you in this particular deal or transaction. So the person is going to go into that transaction or that deal with your power of attorney, because so once that document is in place, anybody can act on your behalf. You don't have to be the one to be there and sign or whatever. Your attorney can do that. And mind you, it doesn't have to be a lawyer. Anybody can do that. You can put in anybody there.
Thank you very much. Thank you. Thank you. I think those are all the questions.
Sir, I have a
So,
question, sir.
Sorry, someone has a question. Richard.
okay,
Okay,
Richard,
Okay,
please go ahead.
thank you so much. Can you hear me?
yes, I can hear you.
Okay, thank you so much, sir. Thank you for this fascinating subject you are taking us through this morning. I've really learned a lot. And to start with, you said you are a realist. I like that thought. That what do we call it? Me, I would say I'm an existentialist. I have quite a number of questions which I noted down while you were taking us. So the first one is about the Federal Supreme Court. So you said that if the case gets to the Federal Supreme Court, the
Supreme
best
Court,
thing
not
to do
federal.
is to go and meet. Okay,
It's
the
not federal.
Supreme Court. Let me see.
Supreme Court.
The-
Yes.
Okay, okay. When the case gets to the Supreme Court, and maybe the judgment is given, and it's not in your favor, you said that the best thing to do is to go and meet God, as you've said in your explanation. Then, what's the place of the international courts, like the international treaties, like ECOWAS court, UNO courts? Can't they be of help? Then, secondly, there was this case recently of Dele Farutimi. They said he committed a case against Ariafe Babalola in Ekiti, but the case were filed in different states. So what kind of court structure is that? Like, if I commit an offense in Lagos, can I be summoned in, let's say, Kano, in Kaduna, in other? Then the second question is this about industrial courts. I want to ask you, as a lawyer, sir, does Nigeria truly have a labor court or a labor law? For instance, I've been working for quite a number of years now here in Nigeria. And to me, I don't think Nigeria has a labor court or a labor law. I've been privy to work in some francophone countries. They do have labor law. They don't maltreat their staffs or their worker. If the staffs have any grievances or any issue, they can easily go to the labor law and their case will be attended to. The third question, sir, is about the 1999 Constitution.
You mean the first
Uh,
question?
The fourth
the
question,
third one.
Richard, the
The
fourth
third
one.
one. Okay, the
Four.
first
No,
one.
that will be number
Thank
4.
you,
We're
sir.
counting.
The first one, sir. The
Mhm.
1999 Constitution, sir.
Mhm.
Is it truly working for us as a country? Because if I'm not mistaken, I got to hear that it was the military. It was the military that crafted the constitution for us as a country. And truly, if you look at how this country is being run, don't we need another constitution? To you, does the constitution not look obsolete? And about the customary law and the customary court thing, recently in southwestern states here, we've been hearing the uproar of some states want to implement Sharia law.
Mhm.
Is it possible? Because when you were teaching us, you said majority of the northern states are the states that practice Sharia law. Is it now possible to implement that in a southwestern state, for instance? And lastly, I want you to please expatiate on these things you said. You said person of unsound mind are liable or cannot are not liable or validly enter into any contract. So that word, can you say more about it? I didn't clearly get that that part. Thank you. Those are the questions.
Okay.
Those are 6 questions.
Uh, Richard came to me with an arsenal
As in,
of
like
questions.
the man came completely packed.
No, not at all, sir. No, sir.
No,
I was
no,
jotting them down.
no, it's fine.
But
It's
excellent, excellent
okay.
questions,
Yeah,
though. Excellent questions.
they're very brilliant questions. I like when I'm teaching. It shows that you're listening. So, first of all, the international courts have no jurisdiction. International courts, their job is basically to resolve dispute resolution between states. So, if there's a legal dispute between two countries, or there's a treaty violation, so or there's a use of force or maybe war crimes, stuff like that. So that is where they come in. That is what they set. That's what they thought they adjudicate upon. And then their other job is also to interpret application of international treaties and laws. So if there's an international treaty that that you a country is seeking clarification, say a country doesn't want to sign that treaty, and then they go to court, so they ask court to interpret so that they can basically properly understand. And then promoting international peace, and justice, also enforcing accountability for war crimes, genocide, or crimes against humanity, and then maybe protection of human rights per se. So those are the jobs of international courts. Not They don't have any jurisdiction to come and adjudicate upon what is handled by a sovereign nation, except when it has it goes against international, maybe for example war crimes or something, or it's going to erode international peace. That's one. Secondly, you asked about the Dele Farotimi case. Well, in as much as we read Afe Babalola, he was a big that was a blatant abuse of court process. But he leveraged on the provision of a law that states that, so you and I have a dispute, okay? The dispute can be filed in a court that is in the place of residence of any of the parties. Afe Babalola is an Ekiti man. He has gone to Ekiti to file, but then Dele Farotimi is in Lagos. So he went to file in Ekiti because he lives in Lagos. Everybody lives in Lagos, but he has a country home in Ekiti. So, but you and I know why he went to Ekiti, because that's his people. You get. So it's just taking advantage of the court's uh, excesses, and then that's just a technical issue. And it's a blatant abuse of court process by filing in so many places. Then three, what was the third one again? You asked so many questions, I don't forget. What was the third one again?
The 1999 Constitution, sir.
Yeah, yeah. The constitution, yes. because the constitution was drafted during the military. But then, today a lot of people have there's serious clamor for a constitutional review, which has been everybody has been up. Everybody is saying that because the constitution that we have today, it cannot, it doesn't solve, it can no longer solve the problems. And there's so many loopholes, so many, agencies are using those loopholes to commit nonsense. And it's a mess. But hopefully one day we are going to get it right. Our constitution needs a total overhaul, especially when it comes to chapter 4, and then also the legislative powers. That's chapter B. That chapter B is also a major issue because there are so many aspects of making laws that are unchecked. So, and these are what NGOs and human rights activists have been clamoring for, a total overhaul of our constitution. But hopefully one day we'll get it right. Hopefully. Uh, what was that again you mentioned?
The Sharia court being practiced in the southwestern part of the country. Is it possible? Is it tenable?
No, it is not. We're not even supposed to. Let us even ask. Let's be real. Why do we have a country and we're supposed to be a sovereign, a federal republic, and we have two different regions that have different laws? It doesn't even make any sense. But then also, there has been some clamors for uh, uh, for some certain states to for Sharia law to be imposed there, which is doesn't make any. But you and I know at the end of the day what some people, some politicians, just let's call it spade a spade. Some of them want, and for Nigeria to be Islamized. You know, they want an Islamic nation. Some people want a select few of the politicians want an Islamic Nigeria, and that's the idea. Yeah, but it's not going to work. It just won't work. It just won't work. Explain to me why Ilorin is considered a northern state. And Sharia law is being implemented in Ilorin, and they kept quiet. And it doesn't make any sense. And Ilorin kept quiet, and then they're trying that with other states. It shouldn't be. I don't want to comment on it much because it's a political issue. I don't like to delve on political issues. That's the much I can say. You asked one other last question. What was that?
Yeah, person of unsound mind.
Yeah, yeah. Persons of unsound mind. Yes, the law is clear that persons of unsound mind cannot enter into contracts. When I say persons of unsound mind, lunacy, uh, or maybe somebody who has uh,
Mental problem.
there are some mental issues, so those people, those particular set of people cannot enter into a contract. Maybe you're out of a health issue, you're not mentally sound, you can't enter into a contract. Whatever you sign or someone makes you sign at that situation is void. It doesn't hold water.
Thank
So
you so
not
very
just
much.
that, not just that, even somebody that is drunk, it moves on to somebody that is drunk or somebody that is high. You're drunk or you smoke something, you're high, and then you sign something. Okay, I'm going to tell you a story. With that also, you can't, not just that, you can't even, not just enter into a contract, you can't even give whatever statement or witness that you give won't be regarded. Okay, let me give you. I handled a case one time. It was a defamation case, and one ingredient of defamation is that that defamatory statement must have it must have become a public spectacle. People are now talking about it. It came from you, you know. So one of the witnesses in that case, so my client was being accused of defaming someone, and then they brought a witness. So during the witness statement, while he was giving his testimony, he said So he was asked, "Where did you hear the statement?" And he said, "Oh, that he was at a beer parlor with his friends. They were drinking, and then somebody said it, and then they were talking about it, and then people it became a, so it, the point they were trying to make was that defamatory statement had become a public spectacle. So when I put him on the witness box to do a cross examination, I asked him again to be clear, where did you say you were when you were when you were when you heard this thing that you have said? And he said he was at the beer parlor. I said, okay, what were you doing there? He said he was drinking with his friends. I said, oh, okay, you were drinking. I said, okay. Could it be that you were high? You were drunk, so you may not have heard correctly. He said, oh, no, no, I wasn't drunk. It was just two bottles. It was just two bottles. The whole court burst into laugh. Everybody was laughing. So at that point, what I have successfully done was discredit that witness based on alleged intoxication. So that goes a long way. So it's not just when you say persons of unsound mind, it's not just when you have a mental problem. Also, intoxication is also part of it.
Okay, thank you for that.
Please, sir, the labor court part, the labor and industrial court part, sir. I missed that
Oh,
part. My network was
okay,
unstable.
okay. Uh, the problem with Nigerians. Nigerians do not fully appreciate the court system. We have a label. No, hold on. Sorry, who's that? Please. Oh shit, sorry. That was okay. The thing is, Nigerians don't fully appreciate the court system. We have active national industrial courts in every state in Nigeria. We have a labor law. But Nigerians, you're working in a toxic work environment. They are doing so many things, trampling on your rights, and you people don't go to court. You don't speak to a lawyer. You don't file anything. So many employees would have been millionaires today if you fully appreciate the court system. We have and they are packed to the. If you go there each day, national industrial courts are packed to the brim. But it's mostly, but it's on the other way around. It's mostly organizations using the courts to to bully their employees. It's got when it shouldn't be that way. Okay, I handled the case before. That was the defunct Polaris Bank. So what happened? So before it was Polaris Bank, they were or the Sky Bank, yes. So this guy was a staff of Sky Bank. So there was an investigation. Some of all this fraud that bankers do. There was an investigation. They thought he stole money, so he was put on suspension, and then they took him to court. At the end of the day, the court discharged and acquitted the guy. He wasn't found guilty. But this case has taken about 5 years. So meaning he was on suspension. So while the case was after, as soon as the court gave the judgment, what they now did was to now dismiss him instead of giving him back his job. The guy left. He took his L in peace and left. But then, while he was a staff of Skybank, while he was a staff of Skybank, he took a loan, and he had not finished paying that loan before this problem started. So after they dismissed him at the end of the case after 5 years, he wrote a letter to them begging them to give him back his job. But now he now wrote to Polaris Bank. Now he was at Polaris Bank. He now wrote to Polaris Bank asking them to give him back his job. That the court acquitted him, that he wasn't found guilty, and that the people that committed the crime have been found. That he just wants his job back. He has a family and all that. Instead of the bank to respond accordingly, what the bank wrote him back, asking him to pay back. Okay, first of all, the bank wrote a first letter saying that they are no longer Skybank, that it was Skybank that gave him a job. That this is now Polaris Bank. That the Polaris Bank Polaris Bank does not have the right to give him back his job. Not long after that, the second letter came in, and then they were asking for money that Skybank borrowed to him. Doesn't make any sense. So at that point, we came in, we went to court, and then they started saying they maintained their stand that they are no longer Skybank. And then we now said, okay, well, how come you're no longer Skybank, but you are asking for a loan that Skybank gave to him? Yes, the bank was defunct, and then the CBN incorporated Polaris Bank, and Polaris Bank was mandated to take up the assets and liabilities of Skybank. So you can't now come to say that you're not Skybank. You were mandated to take up its assets and liabilities. So by that, it's either you give him back. So at that point, it was hell. At the end of the day, they were asked to pay the guy 25 million. This was somebody that was begging for his job, and they paid him the money. They paid him. So the thing is, people don't go to court. People don't. Employees don't appreciate most of the treatments that you get at your workplace. Well, if you just fight discrimination and go to court, you will get a lot of money. Because the labor act specifically talks about discrimination in the workplace, discrimination based on ethnicity or tribe, you know, also the way they treat you. It's very clear, but people don't appreciate it. Also, there's no much sensitization now as well. So, but I think as citizens, we should do better than instead of blaming the government that we don't have these things are in place. It's just that people do not take advantage of it. Yeah, that will be. Okay, somebody is asking, Richard, I'm done with you. Someone saying the
Thank you so
Chinese.
very much, sir.
Okay, he said the
Really
Chinese,
appreciate
Lebanese,
it.
Indians, and other foreign employers are having a field day here in Nigeria because. Okay, you heard about this case in the national dailies. Okay, perfect. Uh, Rablu Wood said, I have seen scenarios where people use what you have explained earlier as,
It's
oh,
almost
yeah,
like a case whereby anybody can claim uh, temporary insanity.
yeah,
People will go to the hospital, and then they'll go
mm,
and backdate a particular hospital report that says that they are unstable. So I mean,
yeah,
people do that all the time, trying to
yeah, yeah.
exploit that. What's that? What did you call it? Somebody
Mm.
not in their what was the
Sound,
name we used?
sound mind.
A sound mind, right senses or sound mind. Yes. So I mean, yeah, I think that's what it is that
Well,
Ramlo
the law is
is.
very clear. The law goes without saying. One of the principles of evidence says, "He who asserts must prove," and you must prove beyond reasonable doubt. So, if you're proving that you are of unsound mind at a particular time, the onus is on you to prove. And if at the end of the day the court doesn't find this substantial, you still have to answer. So it's just the burden of proof. You're just it's not enough to say it. It's not enough to say it, but the burden of proving beyond reasonable doubt lies on you.
Okay, thank you very much, Anthony. I have a question. I
Yeah.
mean, before my question, this class is one of the most interactive classes we've had, and
Mm.
thank you for how you've made this class very interesting for us.
Yeah.
Okay, so to my question, I I understand that before you record conversation, you have to seek consent of
Mm-hmm.
the other party or the second party to record the conversation. But now,
Mm-hmm.
let me paint a scenario: a meeting that started off, on a good foot, and you were recording it, not seeking anybody's consent, but just for
Yeah.
your own documentary, right? And then
Yeah.
along the line, the whole conversation escalated, and then there were, you know, exchange of words that led to fighting, but you recorded as an audio record. Now that would that serve as an evidence in case whatever happened is taken to court? Would that be tenable in the court of law as evidence to show how this whole thing started and how it escalated and how it ended? Can that be accepted in the court of law?
It's called illegally obtained evidence. Okay, and by rights they are inadmissible in court. Okay, so
And what if that
uh,
is the only evidence that points to what really
the
happened? It
court
will still be thrown out.
the court will not pay any mind to it. So, but then while giving judgments, is always at the back at the mind of the court. A judge, because at the end of the day, the what as a judge, your job is to give a judgment or make a decision in the interest of justice. Okay, but then there are so many times when lawyers are going to obtain evidence illegally and then they come to court. Rightly so, the next party is going to stand up and object the admissibility of that evidence. And once the court is going to mark it inadmissible, and then also the court will also make a statement that this statement or inadmissible evidence form part would not form part of the decision of the court. But we find it also that when giving judgment, the judge will smartly not make reference to that particular inadmissible evidence while giving judgment. But when you look at reason behind that judgment, most of the time they pay mind to it. But then there are also some judges who do not, they still find a way to just throw it out and just go ahead and give judgment as though it does not, that statement didn't come up. But some very down to earth ones still give judgment based on that. But it won't, on the face of it, the judgment is not going to, when you read the judgment, it's not going to be based off that. But the reasoning behind it, you can infer that the judge paid mind to that. So it goes both ways. But in practice, it is marked
Thank you.
inadmissible.
Good.
Yeah, yeah.
Thank you very much, Ifeanyi. So, I mean, it is even in audit and in fraud and forensic analysis. The good thing I think is that Emmanuel is here. Illegally obtained evidence, you cannot present it. So we have this question that we're always saying that go to a client site and then one of the employees of the organization goes behind the back to give you some kind of evidence. Can you then judge that thing based on that illegally obtained evidence? No, you can't. So, and even when it comes to privacy, with every global privacy, if you should not record without
Yeah,
taking consent. So
yeah,
consent is
yeah,
like a big deal, and
yeah.
if you don't have consent and you put it, you cannot use it for any kind of formal or legal what did they call it, because you didn't take consent.
Because you didn't
So
take
yeah.
consent exactly, and it's based on that. That's why the court will mark it as inadmissible.
All right, thank you very
Because
much.
it breaches all privacy standards. Yes.
Okay,
So
thank you.
Richard is putting some things here. These things that you lawyers do, where can we get like a compendium of everything? So things like who asserts must
must
prove.
prove.
I'll come to must come to with a clean hand. This thing that they use in calling you people, what's that thing that they call you, the learned one? Is there like a compendium? Is there like a compendium of all these words that you
Well,
people you use
we
in
have
treating
it's
all
called
as
yeah,
eh?
of course. If you go online, you find them. It's called. We have maxims of equity and principle. The things that he said now. The first one is from the maxims of equity. If you go online and you type maxims of equity, Maxims, you find them there. All maxims of equity. And then if you also type principles of evidence, you also see that as well. So those are legal. You find them. Yeah, it's not difficult to find. Very clear. Very clear. But we lawyers, from these are things that we've all been conversant with from first thing university. So we have it at our fingertips. Because from year one they start teaching you all these maxims and principles. You know, yeah.
Thank you very much. Thank you very much
Yeah.
for that. Edith, what's the plan now? Do we go on a quick break and then
All
come
right.
back to the session? Is that it?
Yes. Yes. We'll go on a quick break, and
Yeah.
we'll come back. We'll come back at 12:30.
At 12:30.
Okay,
Okay.
because
Okay.
yes, 12:30.
At
Okay,
12:30,
thank you
we're
very much,
going.
Ifeanyi.
Yeah, you're welcome. At 12:30, we'll continue with property law and then the rest.
Okay, so please do not be late to class. This class has been interesting and very enlightening. So do not be late in order not to miss any part of it. And let's continue from where we stopped. So see you all in a bit. 12:30, we'll get back to class. Have a
Cool.
wonderful break back.
Thank
All
you.
right.
Ifeanyi, thank you
Yeah.
very much for this. Thank
Yeah.
you. Thank you. I
Okay.
appreciate you.
No.
Thanks a lot.
Thank you. Thank you very
Bye.
much.
Dr. These are the kinds of things that Dr. Ruben Abati will say on Arise, am I right? And then we'll be wondering what he was talking about.
Exactly, sir.
So, if I thank you very much for giving us some of these secrets. At least maybe with this one, they will allow us to sit at the reception of of where lawyers meet and gather. They think where the lawyers they meet and gather, maybe they will allow us to sit at the reception. So, but thank you very much. So I put this already in the chat room. I put this in the chat room, everybody. So you can take a screenshot and all that, so which is great. Also the other one that he mentioned, yes, which is the key principles of evidence. So so maybe when you're speaking, please, maybe I think for me everything is very clear. Maybe you might want to shed some light uh, around number 4. If I are here, number 4, and people also say that verbal evidence is a form of evidence. Like me in my audit work, you can't verbal is not really valid, but people say that that verbal contract, that it's a contract, that even though nobody was there, but you and so person agreed verbally. So if I don't know what that is, so maybe you want to speak to us very quickly once I rest my screen about around number 4 and its applicability, and also the concept of verbal contract. If I are you there, if I are you there, right? If I are you there, okay, is it fine here? And lastly,
let's switch out.
okay, so it's not even here yet, right? So but for everybody that is here, these are the kinds of things, we're all business students here. All of us are business students here on this call. So it's important that, so I was looking for the key things that any business student should know relative to law. These are the key things that business students should know relative to law. So when Ifeanyi was here, I know he shed quite a bit of light around number 1. I know he's also shed quite a bit of light around number 3 and number 4. I'm not sure about number 5. My expertise as a person is around number 6. So everybody go and check out something called ISO 37300. It's the ISO standard for corporate governance. We even have clients that want to come to do a lot of training with us around number 6, right? So you should go look at it. And there's also, right, that you also need to look at the Company and Allied Matters Act, the CAMA. That will be useful for number 4, number 6. I'm not an expert in number 7 or number 8 or number 9. I know number 10 very well and 11. So as a person, I'm very comfortable with 6, 10, and 11, because those ones, they're around the work that I do. So 6 is my job, 10 is my job, 11 is also part of my day job. But everybody that is here, we're all business students. We should all take our time to understand all these things. And maybe if as part of what is rounding up this session today, might also shed some light around here. Are you back? Are you back, sir? Okay. So everybody, take note of this slide.
Yes, I'm here. Yes, I'm here.
Okay. All right. So everybody should take take note of this slide, and as part of your closing comments, you might also shed some light. But these are critical things when it comes to business law. When you are not around, I'll say to them that maybe you shed some light on this slide around number 4 and also that thing that they call verbal contract. How valid is a verbal contract? Can two people sit down in a room and agree to something, and then they go to the court of law? How will the judge, how will he determine that matter as it is? And also this concept of burden of proof. When you were not here, I was saying I said these are the things that Dr. Ruben Abati will be using to confuse us on Arise in the morning. Well, now all of us will be staring. So thank you for, in local parlance, we'll say that you have Jawasi. I don't know whether you know what that means. That means you've given us the trick to understand some of these things as it is. So yes, thank you very much, Ifeanyi. Thank you for the first session. I'm sure we'll have a great second session. So please throw some light around number 4, burden of proof or standard of proof, and also verbal contract. And as we round up later, you might also want to throw some light here. So over to you, sir. Ifeanyi, sir.
Yeah. Thank you very much. Thank you very, very much. So yeah, we're going to, yeah, towards the end of the class, I'm going to have shed more light on the other aspects. I already had some that I drafted down. I already have some that I drafted down, but later on, maybe I would give it to the either Edith or what's his other name? Is it Lawal? So he can share it with you guys. Yeah. So right now, I'm going to continue with.
So Ifeanyi, I was asking around burden of proof and verbal contract.
Yes. Those are key components of business law. Yeah, the slides I was
Brilliant.
given doesn't
Brilliant.
really cover. It doesn't really cover most of. It doesn't go in depth. But towards the end, we'll have time on our hands. So towards the end of the class, when I'm done with the slides, I'm going to shed more light on burden of proof, on burden and standard of proof. Corporate governance is the key aspect of business law. So I'm going to talk about business formation and structure, contracts and agreements, uh, corporate governance, a little bit of employment and labor law, intellectual property, very important, and then also uh, taxation, bankruptcy, but also the most important aspect of it all, regulatory compliance in business. So I'm going to shed more light on them towards the end, but let us run through the course outline that we
All
have.
right, please go ahead, sir. Thank you very much.
Yeah. Okay. Um, I want to share my screen again. So, okay. Is my screen visible now?
Yes, I can see your screen is good. Yeah.
Okay. So we're going to try and understand the law of property. So Uh, property law is very simple. It basically defines the rights and the responsibility that associated with owning property, but not just personal property, not just both tangible and intangible assets, real property. How these assets can be acquired, used, and transferred. So we're going to highlight on ownership, use, transfer, control, and disposition. So. Um, So for this is governed by the regulatory compliance and the legal framework for property law in Nigeria is one, the Constitution, Section 43 of from Chapter 4 guarantees rights to acquire and own property in Nigeria. As long as you're a citizen of Nigeria, you have a right to acquire and own property. And these laws are governed by also the Land Use Act of 1978. This act, some aspects of it need modification. Hopefully, in the nearest future, we're going to see uh, a repeal of this one and then enactment of a newer law to cover current practices. The customary law, which applies in some rural areas, case law, which is the judicial decisions interpreting property rights and laws. Then status, we have the Land Use Act, one of them, Conveyancing Act, and other registration laws. So I will shed more light on them much later. So there are some key features in the Land Use Act. Number one, which a lot of people don't like to hear, but that is the law, not just in Nigeria, but almost every part of the world. So every land in every state, that your family land, that your personal land that you went to buy, every land is vested in the governor of that state. So what it means is ownership of that land mean the ownership of that land is the governor of that state that has every land. All you're given is you're more like a tenant, but you have that's what I have called the COO, the certificate of occupancy. When you buy a land and then you get the governor's consent. After you get the governor's consent, and then you get a certificate of occupancy. That certificate of occupancy gives you right to be on that land for a period of 99 years. So a period of 99 years, you of course you're going to leave this world and still have some time on it. Your predecessors, your beneficiaries, when they take control of the land after your passing, maybe they might have about 30 years remaining or 20. At the end of that term, they will have to go back to the state government to renew, to get a renewal. So it doesn't confer ownership in absolute sense, but just a right to use and occupy the land. That's basically what it does. So the customary rights of occupancy. So it's basically where the local government authorities can grant customary rights of occupancy for a land in rural areas. So this is where this takes into consideration the traditional freehold practices. But then recently, there's been some modes or some laws now that has uh, come to override this customary rights of occupancy. We call it excision. So excision is just the government is just trying to be sure that they're in total control. The state government. So like in Lagos, now, you want to buy land, um, you want to, and you ask the seller what title do they have, what title do they have over that property. They will tell you that they have an excision. What excision basically means that the government is saying, oh, fine, we know that your family has been on this land for a number of years, for time immemorial. Yes, we're aware you can continue staying. So they give you that excision. With that, you can stay on that land. But then when when you now want to sell, the person that you are selling to must now have to go obtain a CFO, a certificate of occupancy. So it does away. So the customary rights of occupancy does not transfer to the buyer. So the buyer buys based on that and now goes to regularize his documents with the state government. So now there's some limitations. So landholders cannot sell, mortgage, or transfer their interest in land without the consent of the governor. That is that governor's consent. So you want to sell your land, you must get governor's consent. Or somebody wants to buy, the person that transaction must be consented to the government. That's why at the end of every deed of transfer, deed of assignment, or deed of conveyance, you will see a section where the lawyer drafted uh, where the governor is going to sign. So after that, you take your documents to the land registry, get the consent, get that place signed, and then you register your deed of assignment. Then based on that, you can now go ahead to get your certificate of occupancy and all. So uh, So it's basically just to control, just to ensure proper use of the land. Sorry. So compensation for revocation. So there are so many there are instances where the government can come and revoke your land rights. So that's why, okay, now with this Lagos Calabar coastal way going on right now, a lot of houses were demolished. So the government came and revoked their rights. And the government does this when there's maybe they need to improve on the land, or they need to, to build roads or school or some infrastructure, and that land happens to be on the line where they want to do that. So that is why the government can easily revoke your land. But another thing to pay in mind, which uh, so compensation is paid. Yes, compensation is paid only for the improvements on the land. So if you have the land and you've not done any improvement on it, you've not started any project, you most likely will not get any compensation. Even if you get something, they will give you something, but just a meager sum. But if you have a development on the land, you will be compensated enough for that. But there's something this slide didn't provide. Mind you that yes, you own the land. Maybe you went ahead to buy a land from somebody, but you didn't go ahead to get a governor's consent, or you don't have a certificate of occupancy, the CFO. When the government comes to revoke that land, you will not be paid a dime. So that is why it is always important. As soon as you buy a land, get a lawyer, or even if you can't afford a lawyer, go to the registry and have your make sure that you get the governor's consent and do the registration, get the CFO. So peradventure, there's a reason why the government will come to revoke that land. You will get compensated. So the act also harmonizes traditional and modern land tenure systems. So so when you say traditional and modern land tenure system, so before 1978, it fused in land ownership from time immemorial to modern land tenure system. So if your family has been in occupation of that land perhaps from before 1978, the government still recognizes you as uh, not the owner of the land, but it gives you right. You have annexation. You have the right to be on that land. But any transfer, any mortgage you want to do on that, whatever you want to do, you must get the consent of the governor before you do anything on that land. So the land provides allocation powers to the governor. Uh, Land use and development control, which is specified in the CFO. Then rights, okay, rights of occupancy. Yeah, rights of occupancy. That's the most common one. That's the CFO. Then there's something we also call leasehold. So leasehold is interest held for a fixed period. You can just get a leasehold on that land. Freehold is very rare today due to land use act, but that freehold is basically your family being in freehold of that land before 1978. But so many lands have moved on to the new system now, 99-year period. Then there's something we call right of easement. So you find right of easement in uh, so let us say we have two neighbors who have but who have an adjoining land. They have an adjoining land, but there's a right. So one will now go have an easement agreement with the person, or maybe they can go to court to enforce it. Maybe you're moving for you to move out of your house, you have to go through this person's land. Maybe the people go and block it. So you can now go to court to enforce your right of easement, saying, "Oh, my lord, yes, I and this person will share an adjoining land, but for me to move out of my house or for me to have access to so and so place, I will have to go to this person's land. So I'm coming through the court now to ask for your right of easement, for your right to use another person's land, right of way, yeah, and so many other aspects. And then there's some, licenses, temporary permission to use the land, but these are not proprietary interests, just permission to use somebody's land. So transfer of property. That's what we call the conveyancing or assignment. Conveyancing is the old term for it, but the newer term for it now we call it assignment. So that's the legal process of transferring your interest in a particular land, and it must be in writing, and it must be through deed. So it's not just you can't just write uh, an usual agreement. Oh yes, I'm transferring my land to you. It must be by deed. So deed is what is called a deed of assignment. So deed and titles must be registered at the land registry, and unregistered documents may be inadmissible in court as evidence of title. So you're claiming that you have a land. You and somebody are you're saying, oh, I have a registered deed of assignment. I have a registered deed of assignment. That person has a stronger title. But you go, your lawyer drafts deed of assignment for you and the buyer or the seller, and you don't go ahead to register it. And someone else, maybe you know how, especially with this Omonile, the problem we're having in Lagos is Omoniles. They sell a piece of land to at most 5 people, 5 to 10 people have title. They have deed of assignment. But the first person who goes to the registry to go and register, that's who the government would recognize as the owner of that land. And then you start fighting with the managers. So be sure before you buy a land, ask them what is the title, what title do you have for this property? Some people will give you what do you call it? It's called. They'll tell you that they have a survey plan. Survey plan is not a requisite title to a property, or they will tell you they have purchase receipt. The recognizable uh, property title is deed of assignment, accession, registered deed of assignment, accession, or certificate of occupancy. If they don't have any of this, run, run as fast as you can, because obviously you most likely get into trouble. Uh, Customary land tenure. But this there's no point diving on this because uh, the new laws right now, the new laws, state laws are trying to cut short this customary land tenure. So we may not need to look at this. You can go ahead and look at the summary much later. So the Land Use Act vests land in the governor of every state. Right of occupancy only gives you statutory or customary permission to use land. Transfer must be by conveyance or assignment and requires governor's consent. Very important. So it's not enough to just buy and go keep the documents. Oh yes, we have signed. Take those documents to the land registry and get to the necessary registrations to solidify your title over that land. Now we're going to understand the rudiments of law of contract. For business law, please, you have to pay 100% attention to this. So, what is a contract? A contract is a legally binding agreement between two or more parties that creates mutual obligations. So, what it means is that each party is obligated to perform or refrain from performing certain actions outlined in that agreement. But then there are elements of a contract, basic elements of a contract, and when interpreting what this contract is, if these elements are not there, that contract is invalid. Number one is offer. There must be an offer on table. So there must be an offer saying, "Oh, I want to enter into this." Then there must be an acceptance of that offer from the other party. So then after acceptance, the third key is the consideration. What is the consideration for this offer? Yes, I have accepted. What are we giving me in consideration of your acceptance? It must be something of value. It's either money or services. A promise without consideration is generally not enforceable. So you cannot say, hey, yes, he agreed to do it. I offered this, he agreed, but then there's nothing of value in exchange. Then the fourth one, very important, there must be an intention to create legal relations. So the parties must have intended that this agreement that we're going into, there must be legal consequences. There must be legal obligations that we must carry out. Then capacity to contract. Capacity to contract must have the legal capacity to enter into that contract. So number one, number two, number three, number four might be present, but number five, if it's not there, if you don't have the capacity to enter into that contract is invalid. Example, age. You must be of age, which is 18 years and above. You must be of sound mind. In the last session, I explained what being of sound mind means. So both health wise and also intoxication, you must be of sound mind. Not disqualified by law is maybe when you say not disqualified by law, it means uh, maybe you have been convicted by a court, or maybe there's a there's a court case or something, and there is an injunction placed on you from entering into any particular contract. Let's say two companies are in dispute over maybe trade secret or something, and then someone goes to court to say, "Oh, my lord, please, pending the determination of this case, please place an injunction restraining this particular person from going into any similar contract or going into any contract pending the determination of this case." That's one of it. And also very important, legality of the purpose. The purpose for which the contract uh, is being signed. It must be a legal purpose. It must not be illegal. You and I cannot have a contract for human trafficking. We can't have a contract for prostitution. You can't have a contract for anything that erodes public policy. You can't have a contract for drug business. It must be something that is legal. So, and if any of these elements, the funny thing is, if one of these elements is missing and it's not complete, that contract is not enforceable. You can't enforce it in any law court. Then there are types of contract, express contracts. So express contracts are, in this sense, terms that are stated clearly, orally, or in writing. Implied contract. So terms can be inferred from conduct of parties, okay, from your actions. It can be inferred. Then unilateral contacts are where one party promises something in return for an act. For example, uh, maybe the police is looking for somebody and then they have published a notice saying anybody that has useful information to get this person will be rewarded a particular amount. If you come up with that information, useful information, and they get it and they don't pay you that money, you can sue the Nigerian police. You can sue the Nigerian police. Uh, and also, not just that, there's a popular case, Kabuli Kill versus Smoke Ball. Kabuli Kill versus Smoke Ball. So that is where, in that case, uh, it's just like when you're saying, oh, if you use my product and you don't get so and so uh, uh, services, if you're not certified, if you don't get this, we're going to pay you this amount. That is a unilateral contract. So let us say you go to buy someone is selling what example am I going to use now? Tell you, well, if you buy this cream declares acne in 2 days. That is an offer. That's an invitation to treat. With an invitation to treat, you now go, you may try requesting to purchase that item. You have made the offer. But what the advert that they have given is called invitation to treat. You now make the offer, saying, okay, I want to buy. They accept the offer. And then there's a consideration, which is the money. All all being equal, all ingredients are complete, all elements are complete. Then at the end of the day, you buy the product, you use it on your acne, and you don't, and it doesn't clear up in 2 days. You can sue. you can sue. So, and then bilateral contract is where both parties exchange mutual promises. But enforceability in this case is always very difficult. So that's where I'm going to come back to the enforceability of oral contracts. I'm going to explain that later. So, formation of contracts, A, offer. So that offer must be clear, definite, and communicated to the person. And it can be revoked before acceptance. So there must be that offer. If you don't make that offer, that contract is not complete. Then the acceptance must be unconditional and clearly communicated. Silence does not amount to acceptance. Does not, I don't even understand what they mean by except in exceptional cases, but silence does not amount to acceptance. Acceptance by conduct, yeah, an overt act. You can carry on with an overt act that connotes acceptance. That is also valid. Consideration, it must be sufficient, not adequate. It must be sufficient. Adequacy is not, it must be sufficient. Then it can be benefit to one party or a detriment to the other, of course. Then there are some vitiating factors that can make a contract void or voidable. One, misrepresentation of facts. So you make a false statement, you're trying to get somebody to come and buy your product, you're telling lies. That contract can be void. It can be voidable, but subject to compensation. Then mistake of facts. Mistake of fact is when you honestly, the fundamental misunderstanding, which is honest. So that one, it is voidable. Then for duress, contracts entered into under duress or undue influence by coercion or abuse of power, those ones are apt that they're very void from ab initio. It's void ab initio. Uh, Illegality, yes, that the contracts involving crime, fraud, or prohibited activities are void. Then incapacity, you don't have the legal capacity, it is void. So the only one that is voidable, I'll later the difference between void and voidable. Void is from the face of it that contract is illegal. But voidable is, oh yes, there are some elements that could make this contract void. Or but fine, let us consider these things first. So when you talk about mistake of facts is voidable. Misrepresentation is void. If you misrepresent facts purposely, that contract is void. So, discharge of contract. So, there are certain ways contracts can come to an end. One, performance, when both parties have fulfilled their obligations of the contract. As long as everything is done, the contract is gone, everyone should go their way. Then, by agreement, parties can agree that, okay, the contract will come to end by a certain time. That's why you see some contracts to have term will tell you, okay, fine, this contract will be valid for 2 years. So at the end of that 2 years, that contract comes to an end. But then frustration. So when an unforeseen event like something we call uh, uh, act of God, So when we're drafting contracts, we put it in there. We call it force majeure. Force majeure. So what that means is some unnatural acts or natural events that could frustrate the contract. So when stuff like that happens, let's say a war happens, or uh, there's like a pandemic, just like the COVID-19 pandemic. COVID-19 pandemic brought an end to so many contracts. It frustrated so many contracts. So by implication, those contracts came to an end. Then also breach, when there's a clear breach of the terms of the contract. So you have a clear breach where one party fails to perform their obligations in the contract. So that usually comes with legal remedies, maybe by way of compensation or by way of specific performance. You must perform either. So when it depends when how you decide to resolve the issue, whether you're resolving the issue in court or or by mediation or arbitration. So there's always a clear way how to remedy that breach. So on to remedies for breach of contract. So breach of contract damages. So damages is financial compensation for loss. Then specific performance, which I mentioned earlier, is an order of court asking a defaulting party to perform their obligations in the contract. And when the person doesn't perform as ordered by court, it becomes contempt of court. The person can now be charged for contempt of court. Injunction. So injunction is where an court orders or restrains a party from acting contrary to a contract. So rescission. So rescission cancels the contract and restores parties to original position. So that rescission could be, oh fine, both of us entered into a contract, money has been exchanged. When something happens, we can't go forward. Everybody just give me back my money. Fine. The agreement no longer signing. Everybody goes back. That's called rescission. Then, oh wow, this case was mentioned here. So I mentioned the Kali versus Carbolic Smoke Ball. It's a very that's for unilateral contract where one party offers a contract uh, to many many people. So just like, oh fine, come and buy my product. You're going to get this. You're going to get this. If you don't get this, I'm going to pay you back your money. I'm going to do this. That's called unilateral contract, and that's enshrined in this case, very popular case of Kali versus Carbolic Smoke Ball. So, for essential elements of a contract, it was outlined in Orient Bank versus Belante International Limited. Then, so for the summary table, it's very clear. So, for a contract to be legally enforceable, you must have these essentials, which are offer, acceptance, consideration, intention, and capacity, and then legality of purpose. To discharge each contract can only be discharged through performance, agreement, breach, or frustration. Remedies, damages, specific performance, and injunction. Then torts. So torts is basically an aspect of law that deals with civil wrongs committed against people, which results into a loss or maybe an injury or something. And so this law, what it is, aims to just enforce a duty of care among people, among businesses, among neighbors, to deter malicious behaviors or negligent acts. Uh, there's a, for example, I'm going to give you an example. There's, let's say, a company. Every staff of a company. What if you're acting? If you're acting in your capacity as a staff of that company, as a staff of that company, liability for acts or whatever harm that comes out of that is borne by the company. Is borne by the company. So as long as the person was acting in the course of their duty, I think this it talks about liability later on here. I'm not sure I saw it. That's why I want to mention it now. I'm not sure I saw liability here. So liability for tortious offenses. Liability for tortious offenses for it's called I'm trying to remember the name. I'll get to it later. But for each, while you're working in an organization, if you're working for your boss and you commit any, or you cause harm to maybe the general public or to somebody, the company is meant to bear the liability. Also, with you and your fellow individual, you entered into business with your fellow individual.
Let me explain.
Sorry, sorry.
Yes, hold on. No, it is. So,
Sorry.
good afternoon again. Right. So,
Keep going. Keep going. Sorry. Yeah, sorry about that. Sorry, I had to. So, what this tort law basically does is to enforce a duty of care among businesses and deter negative behaviors or malicious behaviors. Some people also go ahead to maliciously act in a way to frustrate people's businesses, their law of thought comes in. That's basically the essence of law of thought. So negligence. So concept. A business owes a duty of care to its customers, employees, and others. And when a business fails to exercise reasonable care, this breach causes foreseeable harm. It can be liable. So, for example, a manufacturer selling defective products, who was selling it? Those are, of course, they were the marketers. But you're not going to now come and hold the marketers responsible for selling defective products. The liability goes back to the company. And then you talk about defamation. So businesses are vulnerable to reputational damage. Reputation is everything for a business. So that sometimes people are going to come and say make defamatory statements about. And that's why you see. I don't know. Has anyone been following? Uh, it's this Sujimoto's case with this Kotigoma guy, and then Lekki Gardens. This guy has been calling out realtors for overpricing their properties. Now,
Yes, sir.
so now these companies have now gone to write a cease and desist letter from this guy, accusing him of defamation, because what he is doing is is damaging their reputation for them. So, but no, it doesn't go to say that what he's saying is not true. But then you get the point. He's making, but then to prove defamation, uh you know, he must prove to the court that what the guy is saying is not true. So that one is for the court to decide. When they go to court, if they clear up that what the guy is saying is not true, then the guy can be held liable for defamation. So an example here also is where a competitor publishes false claims about a company's products that harms its reputation. So the law. So what the court is going to be deciding based on law of thoughts. Thoughts is what comes into play there. Then another one is trespass. Trespass is something that happens every day. That unlawful entry into not just business premises, but also your personal space, interfering into your possession of your property. So, there you have the right to seek, go to court and get a restraining order. For example, individuals enter a secure business facility or a nearby factory, or disrupting operations or something. You can sue for that. Those are the things because it's affecting your business, it's affecting your space, disrupting your operations, or maybe your neighbor. Let's say you your business is a restaurant, and then you have somebody comes beside you to open, uh, let's say, a factory where smoke is coming out from there, and it's affecting your restaurant operations. You can go to court to sue that this person is trespassing and causing nuisance. So now the court is going to look at, okay, who came in the first. The place is a commercial area. Okay, but the court is now going to look at who came in there first. Okay, you came in, you saw a restaurant. There's some kind of things that you cannot do there. So these are the kind of things that are going to be looking at. So law of thought is very straightforward. But the problem that we have in Nigeria is so many people use the police to solve issues like this. And you know how the Nigerian police are. Nigerian police, most of them are interested in they get money from you, the complainants. They get money from the person that was complaining against. I mean, they just make a nonsense of the whole thing. Nigerian police is not a place, it has been said so many times. Nigerian police is not an institution to resolve tortious offenses. Tortious offenses every day, you go to Nigerian police, you see tortious offenses and they're just there. The police will come and make illegal arrests. So, but these offenses are something that you should, as a business owner, do not waste your time with the police. Go to court. People will even take you more seriously than you going to the police. Mm. Economic thoughts, so where someone wrongfully causes a party to break a contract, or interference with trade, or you deliberately act in a way to disrupt a company's business dealings, or market position, and also engaging in stupid tactics to scare away somebody's clients. But you find in the Nigerian setting, people like to go to police for simple issues like this. When you are supposed to go to court and you are going to get so much money in damages, all you need to do is just prove your case. And some of you may be wondering, okay, fine, I take this person to court, and the court awards an amount of money from. What if the person doesn't have it? Where is he going to get the money from? There are so many ways to get people to pay court fees. So many ways to reap the fruit of your judgment. There's so many ways. We can talk about that later, but I don't want to take so much time. But people people should learn to not take these simple issues to the police, which we see every day. Uh, Another one is passing off. So this is where people try to, an unfair competition where people try to pass off their goods to represent another person's goods. You see somebody like what our bad brothers do all the time. You see Nike, somebody will go and print Nike, the same design, the same everything, the same Nike logo, but the name when you look is Nike. And some people are so short-sighted that sometimes they don't see, they just buy. Or even some people outrightly print Nike on there, you knowing that it's not Nike. You outrightly print it on your brand and you start selling it. Or there's this case, Nigerian chemist company versus Nigerian chemical. So this other company was registered as Nigerian chemicals uh, chemical. I'm trying to forget, but the name was it was similar. And then this guy was also in the same sector, going seeking, trying to get grants. And people actually thought he was that same company. So the other company had to go to court. So he was passing off his goods and services as though he was this other person. So that's very clear. A brand using branding or packaging that closely mimics that of a well-established competitor to confuse customers. You can pay huge damages for that if you're caught in the process. So, what are defenses that you can raise in business talks? So, consent, but it doesn't really hold water. So, this is where people argue that yes, the plaintiff agreed to the conduct, but it's circumstantial. It doesn't really depends on the case. Contributory negligence. Contributory negligence is where someone claims, oh, that the plaintiff's own negligence contributed to the harm. Let me explain this. You guys are in the market. You're bringing in you're bringing in a laptop and you name it uh, HP. HP. This other person is bringing in Toshiba, and all of a sudden your HP is very marketable. Everybody wants HP. Nobody wants to buy Toshiba. And then this guy goes, rebrands his own, rebrands his own to HP, and then goes to go and register HP. He's registered. He went to, because when you go for registration, a search will be conducted. A search will be conducted to know if that name is available. And if the name is available, CSC, the Corporate Affairs Commission, will give you that name. You register. And then you go and do the trademark. You trademark HP. But this other person that has been in the market selling with HP all these years, he did not register his brand name. He didn't register on CSC. He doesn't have a trademark. Nothing, but he has a good customer base. Now, all of a sudden, people are now coming to you, to the other person who has now registered the same HP, both CSA and on trademark, and they're all buying from him. It could be a lower quality, but the fact that he put HP there and people know HP, so he can use the defense of contributing negligence. Oh, it's not my fault. I'm registered. Yes. Why didn't he go to register his own? So that's his own contributing negligence. He negligence on his own part. He contributed to the harm that he's facing. So this is where you're demonstrating that the action was legally permitted or necessary under the circumstances. So another defense is truth. Truth in defamation cases I mentioned earlier, proving that the alleged defamatory statements are substantially true. Then remedies for tortious conduct. Mentioned earlier, damages, monetary compensation for financial loss or injury. Injunction is where a court orders you to stop harmful practices or activities that you're doing. Specific performance is in some cases to restore the injured party to its original position. So you're now asked to, if there was something you were supposed to perform that you did not do, so the court is going to ask you to go ahead and do that and give you a time frame of which if you don't do it within that time frame, you're going to be held in contempt of court. So uh, that's it. So in the Nigerian context, so we're going to talk about the influence of common law. So many principles were inherited from the colonial era, and then it has now evolved through our Nigerian court decisions. Uh, like there are some decisions of courts that are not necessarily, you won't find them in any stated law, but because out of practice from colonial times, most of them there's no enactment to that effect, but through decisions in courts it becomes law. So that's the influence of the English common law. uh, uh, so and then the courts, they try to integrate all these things into business practices, so in order to just protect businesses from harm and allowing healthy competitive practices. So most of these tortious offenses and then its remedies and everything. There is no torts act in Nigeria. There is no law, there's no legislation on all of this, but so it was derived from common law. And when you go to court, there are judicial precedents regarding tortious offenses, and the court just follows those precedents. If you want a review of any precedents, you also go to the appeal court and appeal. But there is no law. So that's when we're telling you that the judicial precedence, case law, is part of the Nigeria, is one of the sources of Nigerian law. So judgments of courts become law. Yeah. So uh, okay, we're done here. Before I go into other, this is not part of the script. It's not part of the course materials, but I want to briefly talk about uh, key aspects of business law. I'm going to chip this in. So before we go into that, do we have any questions for what I have said so far? Are there any questions?
Can you hear me? Mm,
Do we have any questions for what I've said so far regarding property law, and tortious laws, tortious offenses, law of torts? There's something you
I
don't
have
understand.
questions. Hello, can you hear me, sir?
Step away from your mic a bit. Your voice is the mic has swallowed your voice.
Okay.
Richard, you're muted.
Okay, can you hear me now, sir?
I can hear you.
Okay. Okay. Just a minute. I just said the question. Let me read.
Richard, I can't hear you. Maybe if you can put your question in the chat box. Your mic, I don't understand. I don't know
Okay.
if it's your internet, but you can put your questions in the chat box because I can barely hear you.
Okay, sir. I'll put them on the chat box. My network is not connected.
Richard, I think you can put your question in the chat room because your speech is muddled up and so it's not clear enough. All right. Please put your question in the chat room. And does anyone else have questions? This is your time to ask your questions. If you wish to chat in the chat room, go ahead. If you wish to speak, unmute yourself and speak.
If I still have my burden of proof, interpretation. So if you get the chance, so please. Okay.
Okay. No, I will come. I will come to that.
Okay, Richard, go ahead while I think we can move on while we await his question in the chat room. So there will be no dull moments, so to say.
Okay. All right. Maybe I should uh, explain the burden and standard of proof before I go on to talk about key aspects of business law.
Okay, please go ahead.
Okay. All right. So, Mr. That was who asked that, Mr. Orlando, yes? So when you're
Yes,
talking
sir.
about, when you're talking about burden of proof, so burden of proof, it refers to who has the responsibility to prove a fact or a claim in a legal proceeding. The person who has the responsibility to prove a fact or a claim in a legal proceeding, and it can be divided into two main types. So we have the legal burden, and then we have the evidential burden. I'll start with the legal burden. So the legal burden is the duty to prove the case to the required standard, and it usually lies on the party bringing that claim. For example, maybe if it's a criminal matter, it lies on the prosecution. If it's a civil matter, it lies on the claimant or plaintiff. So that duty, that legal duty to prove the case, lies on that person. So in criminal cases, it's basically for the prosecution to prove the defendant's guilt beyond all reasonable doubt. In civil cases, is for the plaintiff to prove their claim, prove their case. Then when it now comes to evidential burden, I'm still talking about burden of proof. When it now comes to evidential burden, so it is the duty to produce enough evidence to raise an issue that must be addressed by the other party. So when we go to town, make sure you produce enough evidence that to raise that issue, and that every single evidence that you raise up must be addressed by that other person for every single one that you bring in. And then know that this evidential burden it shifts during trial. It's evidential burden because as you're proving your own evidence, the other person is also disproving it by providing evidence to disprove the evidence that you have brought. So in self-defense, the accused only needs to raise enough evidence to make it a lie. They say, okay, I did, yes, I didn't. You bring evidence to show that I didn't commit this offense. Oh, I wasn't there when this offense was committed. You now have to prove his alibi. So once he proves his alibi, that burden of proof automatically shifts on you, the prosecution now. So that is the burden of proof. Then for standard of proof, in criminal cases, it is beyond reasonable doubt. So the prosecution must prove that the defendant's guilt is so that there is no reasonable doubt that he's the person who committed that offense. It does not mean absolute certainty, but the evidence must be so convincing that a reasonable person will have no doubt that this person committed this offense. And how do you do that? Each offense has its ingredients. You must prove the ingredients of the offense and tie the person to all those ingredients. Let us say rape now. Rape is one of the most difficult offenses to prove in Nigeria. One, what are the elements of rape? One, that there was no consent. Two, that there was penetration. Yes, okay, fine. You go to the hospital, you're sure the girl is examined, it's obvious that she was penetrated. There's medical evidence. Now you now start talking about linking that penetration to the accused person. DNA samples. Did they take a DNA swab? Did they take a swab? Can they link these DNA samples to this person? The only other way to prove it is maybe via circumstantial evidence if the testimonies and corroborating testimonies is so much that it is said that this person is the person who raped this young lady. So that is the standard of proof for criminal cases beyond reasonable doubt. But for civil cases, it is the balance of probabilities. Balance of probabilities. So the claimant must prove that their version of the event is more likely to be true. What I'm saying that is what happened, my own is most likely true. So it's the balance of probability. So the court will now have to now choose whose story is more credible. So for clarity now, let's say in a criminal case, a man is accused of theft. The burden of proof is on the prosecution. Sorry. The burden of proof is on the prosecution. They must prove beyond reasonable that the person actually stole that item. Yes, he caused this thing to move from point A to point B, and he was the person who took it. So many eyes saw him. In a civil case, a woman sues for, let's say she sues for a breach of contract. She sues a company for a breach of contract. So she has the burden of proof to show that a valid contract existed and it was breached. That's all. That's all. And then she must do so on the balance of probability. Yes, yes, we had a contract. You breached it. These are things that happened that led to you breaching it. So I don't know if I've explained this burden and standard of proof to you properly.
Thank you very much, Ifeanyi. I think the part that is always confusing, you addressed it, is that thing where at the beginning the burden of proof is to one side, and then you clarified it that it also then shifts
Yeah, it shifts. Yes,
during the proceedings.
because if I prove, the burden shifts on you to disprove what I have proved.
Right.
So that's the shifting characteristics of burden of proof. It shifts. So
Good. Thank you. Thank you very much.
mm, Messi, his song is saying, "I want to digress a bit. In the case of divorce, what happens that the case is prolonged, and if it is the fault of one party, what action can be taken for the papers to be signed?" Uh, well, this your question. Yes, you're digressing. We're talking about business law here, but uh, first of all, let me correct you. We don't sign divorce papers in Nigeria. In Nigeria, we go to court. We go to court. It's not like the Western system where they they call it divorce arbitration, where parties just sit down with their lawyers on the table and then they sign papers. No, it's not the way here. You have to go to court, file a petition for dissolution of marriage, file a petition for dissolution of marriage, and then the court. Uh, Nigerian courts are not quick to dissolve marriages, and that's why it's difficult here. So you go to court, the court will now look at the testimonies, and the court will only grant that dissolution of marriage where it is reasonably believed that both parties cannot be expected to live together anymore. Beyond all, they, they can't coexist with each other anymore. So, but then there are certain things that prolong the issue. Some technical issues, or especially where there are children, the court is going to forget the two of you because now the court is thinking about the best possibility. The court's interest will be in the children to make a decision that will be in the interest of the children. So the court is first of all going to decide on how the children are going to be taken care of before the court will come back to whether you guys are willing to dissolve or not. So there are so many things that prolongs it. It's not just one thing. Um, Richard is saying, um, Thank you for shedding more light into the number of years allowed to own and occupy land in Nigeria. Well, what of the case where the land is an ancestral land that have been passing on from generation to generation? Do you still need to renew it with the government? That's why I mentioned earlier. From the moment yes, it's an ancestral land. The moment that land is sold to somebody and the deed of assignment is signed, the person, it automatically behoves on the person to now go to the government and do a proper registration. But if his ancestral land is still within the family, no problem. But the moment he moves from the family to another person by a sale, he must go to the government to get the governor's consent and then also apply for your C of O. Because if peradventure the government now wants to retake that land, because the government can still retake it from the family, pay them compensation. But upon sale, if it has passed on to another person, the government wants to reclaim that land, maybe to build an infrastructure or something, and you do not have the requisite registrations, you won't be entitled to a dime in compensation. So you have also said what exactly is title deed or deed of assignment or deed of title. So deed of title is the legal instrument that you can use to transfer title in property, title in land from one person to the another. So it is drafted. It's a deed that is it has some components, some specific components that makes it a deed inside. So tomorrow you can pick up a deed of assignment, you look at it. It's not your usual agreement. It has some statutory things that if those statutory clauses are not in it, it is not a deed, it is a mere agreement. So it is that deed of assignment, it is that document that you say, yes, I have my title deed, I have my deed of assignment, I have my deed of conveyance. This is what I have. So says under unilateral contract, does whistleblowing fall under this? But whistleblowing is a whole different spectrum. It's a whole different spectrum, so it doesn't fall under it. So someone said on force majeure and trespass, I would like to ask via the microphone. Okay, fine. Yeah, you can go ahead.
Oh, okay, thank you, sir. Am I audible enough now?
Yes, yes, go ahead.
Oh, okay, thank you so much, sir. I've really learned a lot in the course of this training, and kudos to you, sir. Thank you so very much. So, the question about force majeure is
Mhm.
related to where I'm working presently. So, I just want to ask to know, in case my company is doing a bad business, maybe with a partner that is not based here, and the company is running at loss, can it be considered as force majeure? Because as you were explaining, you said environmental disaster and some other thing. Let's assume I'm shipping to a country and maybe on the sea there was turbulence, maybe the container falls off the sea or there's fire outbreak. That's force majeure, right? But
Yes.
if maybe with the person I'm working with, the consignment or the goods got to them successfully, and at the end of the day, it turns out to be a bad business. Maybe they are not paying up, they are not
Mhm.
forthcoming with the agreement. Can it also be tagged as force majeure?
No, it comes under breach of
Then
contract.
the last one,
It
okay,
comes
breach
straight.
of contract.
It comes under breach of contract because they have obligations specified in the contract, and when they don't live up to those obligations, it's clear breach of contract, which you can claim damages for. And I'm sure each
Okay,
each
okay,
each
okay.
contract
Well noted.
agreement each contract agreement already specifies for the remedy that is going to come to the person, to the victim, when a breach of contract occurs. So lawyers will tend to include everything in the agreement already.
Okay.
Yeah.
Oh,
Okay. So are we done? So I can go ahead to talk about key aspects of key aspects of business law.
why reading and teaching us? Something meaning someone trespassing to my property. That's the last question, sir.
What? I didn't hear you. Richard, please, I didn't hear what you said.
Okay, should I repeat the question?
Yeah,
Can
you
you hear
said.
me, sir?
Go on.
It's my network. Okay, I said should I retake the question?
Okay, go ahead.
Okay, about trespass, I have a property and someone should trespass, and I happen to have a gun at that time, and I shot
Mhm.
at the person. Let's assume the person is a thief or a robber. Am I going to be held responsible or liable? Can I be charged to court for firing or for shooting at anyone that trespassed into my properties? That's the
First of
question, sir.
First of all, the question is, do you have a gun license? Does the Nigerian legal system give gun
That was the
license
first,
to
that was the
individuals?
first thing I was going to. That was the
Yeah.
first thing I was going to say.
You have,
That your legal. Do you own it
so
by?
yeah, yeah. So assuming we're in the US where so many state laws give you can have the right to own guns according to the ambit of the law. So yeah, fine. But then it's not even straightforward because you must also show. Let's say you're not in Nigeria, you're not now. You must also show that you took reasonable, caution, fired a warning shot. First of all, warned verbally, fired a warning shot before you eventually shot the person. But Nigerian law, we don't have gun license. Nigerian government doesn't issue gun licenses except you are a member or retired member of the Nigerian Army or Nigerian Police. Even retired members of Nigerian Police, they hardly get it. They hardly get it. So you must be a retired senior police officer or retired senior member in the Army or Navy or Air Force before you can even get a gun. So your question does not
Are you
hold.
serious? Are you serious? So people can't own. Wow. So
You can't own
okay.
a
So
gun.
so all the people who do hunting and everybody has a ding gun and all that.
No,
Under
no,
where?
no, no, no. Except there's an exception to
Okay.
hunters. But for
Okay.
hunters, first of all, you must register. There's a hunters association. You must register, and then there's a caliber of gun that they use. They don't have sophisticated weapons. In fact, when a Dane gun hits you, it's not fatal, depending on the range and everything. So those are the only kind of guns that they can use. But you have to have the registration. You must be a registered hunter.
Ah, right,
Yes.
right,
Yeah.
right. Lastly, for me, if I is so I've always wondered, where somebody who's on the lower cadre economically and they cannot afford a lawyer, is there a provision either at the state or federal level to go and meet somebody and then they will assign legal help to you that
Yes.
will cost you nothing.
Yes. The court provides. Yeah, the court provides for pro bono services. If you can't afford a lawyer, the court will assign one for you. Let's say
Right.
let's say you're you're handling a criminal case. There's so many times we'll be in court and defendants are maybe people who are brought in from the prisons and the court is trying to get them to, maybe it's time for them to make their plea on arraignment, and then the judge or magistrate will ask them, do you have a lawyer? And they say no. Do you want a lawyer? And then he won't know what to say. The court will ask, would anybody here, is anybody willing to take up his case and help him through his plea? A lawyer will stand up and help the client. And then eventually, after that, the court is going to ask the person if they want the state services for a lawyer. You just apply, and the court they will assign a lawyer to you to handle your case.
But in reality, once again, in terms of effectiveness and efficiency, is this ever effective or efficient? Like, are you
It,
guaranteed that state
it
service will
is.
come within the right period?
It is. It's just that one of the problems that we have is funding. Is funding.
Okay.
One. So now, what the courts don't fund these lawyers, so none of them are eager to help. They're not eager, they're not eager to
Wow.
help, and then the courts now try to take advantage of what do you call them? human rights activists, organizations,
Right.
and some of those organizations, they are also low on funds because they work with grants and donations from people.
Okay.
So that's why what what those organizations do is maybe every quarter they're like, okay, this is how much we have, this is the number of people we can handle pro bono, and then they go to prisons, pick a number of. They said, okay, we're going to Kirikiri today. We're going to take 5 people that need legal services that can afford legal services. So they can interview 50 people. At the end of the day, they take 5 people. They can't help it because they are working with the funds that they have. So it's just
But the
that
state services that you said, isn't that like formal, whereby the court pays those their own lawyers, but they are not a lot? Isn't that
yeah.
like a thing in itself?
How many of them we have state services like that? But how many lawyers are there? How much is the government paying them?
Right,
So that's the
right,
issue. That's the issue.
right,
We have that, but the problem from the government is funding. We have that. The
right.
problem is funding. That's the issue.
Okay, all right, that's fine. It's so that you can go ahead and round up. All right, okay, go ahead.
Okay.
Thank you.
Yeah, it's almost 2 p.m. So
Yeah, so it's
I'm going to quickly rush the
I don't part.
so yeah. So for key aspects of business law, there are key aspects of business law. Please, you can make notes if you want, because I'm working with my own notes. One, business formation. Okay, the class is recorded, so you can always listen later. One is business formation and structure. That's number one key aspect. Business formation and structure. Then we'll look at contracts and agreements. We're going to look at corporate governance, so the roles and responsibilities of directors, shareholders, and officers of the company, corporate compliance, all that. We're going to look at employment and labor law, intellectual property, regulatory compliance, consumer protection, thoughts in business, and dispute resolution, best possible business resolution for businesses, mergers, acquisition, bankruptcy, stuff like that. Taxation also important. So I'm going to go through all of them quickly. We have a few minutes. So one, business formation and structure. So first key is to understand the legal foundation of a business. It's very, very essential. So there are so many ways that you can form a business. So it's either through sole proprietorship, that's owned by one person. There's minimal regulation requirements. So this is where you can register as a business name. Okay. Then we have partnership. Partnership is where two or more persons can own a business. So it can be a limited liability company or it can just be a partnership. And then their partnership agreement is going to define their duties and their profit sharing. Then we have the limited liability company, which is the most popular one. So it's a separate legal entity and it protects the owner's personal assets. So the assets that are here is the assets of the company, not your own personal assets. So all of you come, set up the company, have your shareholders agreement, set up your share structure, and everybody is going. So if you're raising money for a project, everybody is raising money according to the number of shares that they have in that company. So there's a debt the company needs to pay, you also pay according to the number of shares that you have. Sorry, who's that? Sorry, Lawal, please mute your mic. Okay, it's muted now. So you're just your assets and liabilities that you're gaining, or your dividends, shares that you're gaining from the company is according to the number of shares that you have. Then some key considerations that you must look into here. So you look at your liability exposure, the tax model that you want to go, your management structure, very, very important, and then capital raising capacity. So these are the things that you must put into consideration while forming a business, regardless of the structure, whether it is a limited liability company, a partnership, or a sole proprietorship business. Then another key aspect, contracts and agreements. Contracts and agreements, very, very, very important. See, they're very, very essential to your business operations. We talked about contracts now, the key elements of a contract. The offer, acceptance, consideration, intention to create legal relations, capacity, and what's the last one? Legality. So there are so many types of contracts that you can use while in your business. There's some, depending on what you do. First of all, with your staff, you do the employment contract. Depending on the type of business you do, there's you can call the service agreements, service level agreements, lease agreement, memorandum of understanding, NDAs, confidentiality and non-disclosure agreements. These are very key documents that we use in everyday business. Especially for that NDA, that is called NDA, non-disclosure agreements, confidentiality and non-disclosure agreements. I'm going to tell you a brief story. I have a client, he went. In fact, this guy used to be in fact, he's my good friend. I've known him from school. He was my roommate in school at some point. He decided to start a business. He came to me. Ah, well, look at what I want to do. What do you think? I said, yes. Well, let us do a memorandum of understanding, service level agreement, and an NDA because you are going to be dishing out trade secrets to this guy. Your trade secret is in his domain, so we're going to have confidentiality and NDA, non-disclosure agreement, a service level agreement, and then maybe an MOU. The guy said, okay, how much is it? I gave him my bill. He said, why you self? Why are you doing like this? Me and you were friends from. So I said, yes, now. But I'm not going to come to your business tomorrow to buy a product or seek your services and you do it for me for free. Bring money. Eventually, I didn't hear from this guy. He left. 2 years after, he called me. Oh, you won't believe Chukwemeka. You won't believe, he's now doing the same thing that I'm doing. He's doing this, he's doing that. Every same thing that we talked about, all the things that we talked about, he just replicated it and he's doing it for his own business. I said to him, I mean, what do you expect? What do you expect? Now you've leaked all your trade secrets to him. He's doing the same thing, and two of you are now in the same. In fact, your office building is not far away from him. You're doing the same thing basically. He has now moved away from what he's doing before, and now he's doing the same business that you're doing, and even better than you. What do you want me to do? You can't even go to court. You can't. 'Cause it's not like you guys sign. So you have your trade secrets is one key aspect in your business. Protect it all the time. Always document your agreements in writing, include dispute resolution and termination clauses. And also, please, there are some things my colleagues do that we don't like. So you're drafting an agreement that laymen are going to use for their business, and you're putting ambiguous law terms. It is advised to have your terms in the agreement as explainable and very very straight to the point so that everybody understands what they're signing. So that you don't sign and then tomorrow you go to court and you're saddling the court with interpretation of legal documents. Then corporate governance, this is the heart of the company. This is the heart of the company. So it focuses on how a company is directed and controlled. So you're going to look at the key players in your business. Sorry, excuse me. Okay, sorry. So no, not that one. Keep it over there. Just close the door, please. So it involves the key players in your company. So you're going to so if it's a limited liability company, so you're going to have a board of directors, then shareholders, and executive management. Very important. That delegate powers. Delegate powers. Don't be the alpha and omega in your company. You see somebody, you open a company, he's the only director, he's the only shareholder. He'll not come and tell you he's MD CEO, MD CEO, chairman of so and so sons. You don't have a structure. You are the only person there. And then tomorrow you want investors to come in. They're going to look at your books. They want to look at your board structure. And when they look at it, they say that, oh, you don't have a, they won't invest in, they won't give you, they can't trust you with their money. So Bring in as much people, bring in investors, can start small with your friends or something. Have a board of directors, shareholders, all your documents should be separate. Then have an executive management that manages this company. You as the promoter of the company, just allow employ management staff, let them work. Sit back with your board, take information, make decisions with the board, delegate tasks to the management staff. Governing documents. Be sure that you have your governing documents. That's your articles of association, your memorandum and articles, shareholders agreement. Very important, because when you go for companies at AGMs, is chaotic. You see shareholders screaming at each other. Make sure that you have shareholders agreements that are watertight and very, very clear on procedures. Board resolution before your company goes into any business with anybody, or before your company goes into any make sure that there's a board resolution authorizing the company. Remember, you and your members of your board must sign a resolution authorizing the company to go into that business transaction, so that tomorrow one director is not going to come to the board, stand up and insult all of you, or then there'll be chaos. And once that begins to happen, the company is just on its way to damnation. So everybody must be in agreement for each contract or whatever transaction or deal that you're going for. So, and then the directors, you owe each other duty of care, loyalty, and you must always act in good faith. Always ensure that you have regular board meetings, and compliance findings are required. That's why I said ensure that you can't be the director and be the manager at the same time. You can't be a director, you can't do everything yourself. Employ a management staff, have your CFO, your chief financial officer, have your legal team, have your key players in the office, in key chief technical officer, stuff like that. Make sure that all compliance is being filed. Check your business, what uh, what industry is your business operating in? Is there a regulatory body for that industry? Are you filing the requisite regulatory returns or regulatory requirements? Stuff like that. Are you filing your yearly CAC returns, your annual returns to CAC? Are you filing them? Are they up to date? Is your company regulated by the CBN? Are you doing your board evaluations? All stuff like that. And then comes to another aspect is employment and labor law. So this is another. If a company, if you don't treat your employees well, your company will not go far. Promise you. One, so recruitment and contracts, you must comply with requisite labor law wages, benefits and working conditions. There are so many companies, you're paying your staff salary, you're deducting tax and pension, you're not remitting tax and pension to requisite offices. They will pay you your salary. At the end of the day, they will say, "Oh, yeah, tax deduction, pension," but you're not getting, you don't even have a pension manager. They don't sign you up with a pension funds administrator, nothing. Tomorrow you want to do something, maybe you want to, let's say your father died now, God forbid, you want to go to court and apply for letters of administration, and then the court mandates that you submit your your tax returns, your tax clearance certificate for the year, and you now go back to your company. Oh yes, you've been deducting my tax. Please, I need the. Can you forward me? Can you refer me to the tax office? You give me a letter of introduction so I can get my tax clearance certificate. And you find out that they have not been remitting your tax. So, also termination. If you're terminating employment, it must be lawful, documented. Because if you're not careful, wrongful termination can lead you up to litigation. And as a business, the worst thing you want to do, the worst thing that can happen to you is to be dragged around in court, most especially by an employee. If it gets to the National Industrial Code, the National Industrial Code always has the interest of that employee at heart, because they know how Nigerian companies, not just Nigerian companies, companies in general treat employees. So rights and protections. Make sure that you have important policies in place in the company, anti-discrimination policies, workplace safety policies. You know, allow if you can, if it's a big company, you can allow union activities. Don't be too uptight. Then intellectual property. This is apart from making money on the ground, another thing that is important for a company is your IP. You must have a good IP portfolio. IP, intellectual property. Have a good intellectual property portfolio. Be sure that you protect the creation of your mind, because your business idea, your trade secrets, all of those are your intellectual property. That the creation of your mind, and it is protected. It can be, it's protected under Nigerian law. So make sure that you do your trademark registration. What is trademark? Trademark is where you register your brand name, your logo, and your slogan. You can go to the trademark office, register that. Copyright. So if you're into maybe computer programming, or you are is a record label or an artist or something, make sure you go to the copyright office and protect your literally works, your software code, everything. They protect it for you. Then patent is for inventors. If you're in the habit of inventing new, if your business is into inventing new products, you must also patent. It's called patent. Patent those inventions with the IP office on your industrial processes, how you came up with that invention. So you patent it, and what it means is that you're going to have outright outright uh, use. You're going to have exclusive use, exclusive. You're going to gain exclusively on that for a period of years. I think it's 20 years. And after 20 years, anybody can now bring up the same thing, and you want. So for 20 years, you're gaining from your invention without anybody disturbing you. Trade secrets, you can also register your trade secret, business formula, the methods that you're using, all those things can be registered with the IP office. And this, it prevents unauthorized use, and it gives you a competitive advantage. So another aspect that can hurt your organization is if you do not follow regulatory compliance. If you're not regulatory compliant, if your business is not regulatory compliant, I mentioned earlier, every business must comply with the industry specific and general laws. So if your business is like, if you're, like, for example, CAC, the CAC is not enough for you to register a company with the Corporate Affairs Commission. You have to always file your annual returns yearly, telling them, oh, yes, we've been doing business. This is our net assets for the year. This is our turnover for the year, just to make sure that you're carrying on business. And then there are some things that you need to do. Maybe your company wants to uh, go into a mortgage or something, a debt financing or something. It must be registered with the CAC as well. So if you're into the process, or maybe you're making food and all that, and NAFDAC, if you're into financial, uh, if your business is into financial services, you must also register with the SEC, which is the Securities and Exchange Commission. For sectors like banks, CBN, if you're into oil and gas, the DPR, that's the Department of Petroleum Resources. If you're into data protection or data, you're handling people's data, like MTN, and whatever it is that you're doing, as long as you're collecting people's data, you must register with NICTA, the the Nigerian Data Protection Commission. So be sure that you have a comprehensive compliance framework. You know. Now, another aspect is also consumer protection. You know, be sure that if you're into products, if you're offering products and services, so you make sure you're in compliance with the Consumer Protection Commission, the Federal Competition and Consumer Protection Commission. You be sure that you're giving your consumers right to safety, right to information, right to redress if they feel, if they don't feel, if they feel or they don't get services or goods services that they paid for. Give them room for redress. And also make sure that you have a quality assurance scheme, fair refund and return policies, transparent advertising, very important. Transparent advertising. Some people advertise, you're telling people stories that are too good to be true, especially these betting companies. Then the people come in betting companies, all of them are in court, or if not all of them, if not all of most of them, if not all of them, are in court. Then be sure that your thoughts, you're very very knowledgeable with your thoughts. Be sure that your company is not no negligence. Make sure that your premises is safe. Make sure that you don't go ahead to make false statements or malign another organization just to push your own. And then don't engage in fraud. So be sure that, and vicarious liability plays. That's the word I was looking for before. Vicarious liability. So this what vicarious liability means is that employers can be liable for employees' action done in the course of employment. So be sure that you sensitize your employees on how to carry on to do their work very well. Make sure that they are following company industry standards. You not being negligent, they're very, very diligent in what they're doing, because if anything happens, as long as it's proven that they are doing what they are doing in the course of their employment, the employer, you will be held liable. So dispute resolution, I can't stress this much. As a business, anything that would bring you in court, please avoid it. Please avoid it, because court-based resolution is public. One, you don't want your affairs to being public spectacle, be a public spectacle. One, court-based resolution is public and it is very lengthy, very lengthy. Companies are in court for 2, 3, 4, 5 years. You're paying a lawyer every you're paying, just check the amount of money that you're spending by paying lawyers in courts, transportation, even you check all that. If you put that amount into services that you're offering, you're going to make more money. So anything to avoid that. And how can you avoid that? Embrace ADR. What is ADR? ADR is called alternative dispute resolution. So for each contract agreement that you're going into with another business or an individual, be sure to always put in an ADR clause. Dispute resolution, that okay, that you can in the event of any dispute, parties agree to settle. Just offered just in the event of any dispute, parties hereby agree to settle amicably through negotiations, understanding each other. Then failing which, within 14 days, if the parties don't resolve this dispute, parties agree to settle their dispute via mediation or via arbitration. The parties are going to select the arbitrator, who the arbitrator is going to be, or who the mediator is going to be. And the parties hereby agree that whatever decision, the decision of the arbitrator or the mediator is going to be final and binding. You people have solved, you've not even entered any problem, but in that agreement, you have solved your problems. So if there's any dispute regarding any particular aspect, you guys know that there's already a set way how you guys are going to resolve these disputes. And it's very fast, cost effective, and it preserves your relationship. So, lastly, I'm going to talk about taxation. Be sure that you're tax compliant, because you don't want to get in the bad nets of FIRS. Be sure that you're tax compliant. Get a tax consultant. Get a tax consultant that is following the tax obligations of the company. Be sure that you pay your company income tax, your value added tax, you pay tax for your employer for your employees. Make sure that you file them, annual returns, tax remittance, compliance. Have a full tax planning structure, methods to minimize liability and ensure efficiency. So yeah, so that will be the end. I hope well understood. And if you
All right,
have
thank you very much. We cannot thank you enough for this.
mm,
I've actually enjoyed listening to you even better than listening to myself. So this has been an interesting class. I've been a part of it from the very beginning when you started speaking, all the way to this particular moment. So thank you very much. I've
You're
thoroughly
welcome.
enjoyed myself. I'm definitely going to go back to the slides, and then I'm going to look at the slides and listen to this recording all over again. I
Okay.
almost feel like if I know to a large extent the things you taught us today, I might be able to pass off myself as a paralegal or something like that. So if I thank you
Thank you
very
very
much.
much.
Really
Thank
appreciate the
you.
time. I have completely enjoyed myself. This has been enlightening for me as
Thank you
a
very much.
person. So thank you. We appreciate you. Okay.
Thank you, Mr. Lumide. Do we have any other questions? Richard, you want to say something? Any other person want to say
No, I'm
something?
not saying anything. Thank you, sir.
Okay. Okay. Thank you. So, in the absence of any further questions, we have come to the end of today's class. I thank you all for your active participation. It feels good when you're speaking to people and they're actively participating. It shows that you're passing a message across, and I appreciate you all for that. So thank you. Hopefully, at another time, we might meet each other. Okay, that's it from me for here. Thank you
Absolutely,
very much.
absolutely. Absolutely. We might even refer some work to you. So thank you once again. We
Mhm.
appreciate you.
Yes, sir.
If I thank you for your time. God bless you. Thank you very
Thank,
much. All right.
mm,
Over to you,
thank you.
Mercy. I think that's the end of today. So thank you very much, everyone.
Thank
Have a
you.
great remaining part of your weekend. Lawal, well done. Richard, well done. Faisha, Shoaib, and Emmanuel, and everybody that is here. It's definitely great being here with all of you today, and we look forward to seeing you next week, Saturday. So thank you very much. Have a great weekend, everyone. Thank
Thank you
you.
so much, boss. Have a
Thank
wonderful one
you.
too. So the recording and the slides used today will be sent across to every one of us by the coming week. All right. Enjoy the rest of your weekend. Bye for now.
Bye.